Psst. She's on Kijiji.
Buying or selling? I can't see.
Buying. Home decor.
Again? How much sweeter can she make this place?
Wow.
Good morning, everybody. I think we've got everybody on now. Am I missing anybody? I don't think so. Oh, okay. Well, good morning for the third day of hearings. I wanted to talk to all the parties this morning. Yesterday, we said that we would come back today with a framed-in formal supplementary submission invitation for the whole issue on jurisdiction. And so we worked on that last night and this morning, and we're not yet comfortable with the version that we've got drafted. So the tribunal members, with your indulgence, are going to work later today after the hearing to make sure we get this right, and then we will be sending that out to you correctly. Is that okay with everybody?
That's fine with us. Thank you.
Okay.
Hi, thank you.
Yes, of course. Okay.
Okay, thanks. So yesterday we finished off with a very good presentation from Matthew and Jenna. Ann. And before I open up to questions from council and panel members, I just wanted to ask Matthew and Jenna if you had any final remarks did you want to make on that?
No, I don't have any additional remarks. Happy to answer your questions. Jenna, did you have any additional comments?
No.
Okay,
no,
so
I don't. And I do have, I don't have any additional comments to add at this moment. I was going to add that I have the slide presentation, if that would be useful to assist with questioning, that I can pull up onto the screen again.
Okay, well, let's start with the questions then. So Kirk, did you want to lead us off?
Morning, Council. I wanted to go through a short list of questions here, starting with the notice of constitutional question that Baffinland has filed. And the last item in that NCQ is a claim of discrimination under the Canadian Charter of Rights and Freedoms. And I'm wondering if that claim is going to be advanced before the tribunal here.
No, it is no longer being advanced.
Okay, thank you. Now, when you look at the Nunavut Inuit Land Claims Agreement at Article 22.2.3, it provides in the second paragraph there, notwithstanding where an improvement has been constructed and an area of land for that improvement has not been demised, the assessor may assign an area no greater than 4 times the total ground area of the improvements. And I wanted to ask a few questions so that it was a little bit clearer what had occurred here. So the first thing is, do I understand that your position is that there is a demise, and it is a demise of the areas that over which there is exclusive possession for Baffinland?
Yes, that's correct. Our position is that there has been an area that is demised for the improvement that are identified in the commercial lease, and that does not include the general areas or the tote road.
Right, so it's the impact areas and the exploration areas as they are defined in the lease.
That's correct.
All right. Is there a map in the record that shows the geographic extent of those areas, the impact areas and the exploration areas?
I would have to double check. I believe there's a description in the lease, but I'm not sure if it's up to date. So I would have to go back and check the record to see what maps are included or not.
May I ask you to do so?
Yes.
Okay, thank you. So what is your understanding of what the government of Nunavut did? Did they take the position that there was no demise in their assessment of the here?
So my understanding is that they've treated the entire area that is dealt with in the lease, including the general areas, as being accessible for tax.
All right, Mr. Secretary, can you pull up the map at QIA 1330? we looked at this, I think, a little bit earlier, Council. This is a map of what I understand to be the leasehold areas.
That's my understanding as well.
Thank you. Okay, so I wasn't sure how the government of Nunavut treated the question of a demise. Did they take the position that all of those leases were demised? Or did they take the position that all of that was not demised and they multiplied by 4?
So they didn't multiply by 4. That's clear.
Okay,
I'm not sure how they dealt with the issue of demise or if the assessor turned his mind to that question. What is clear is that they have assessed the general areas and they haven't used an area, the area that they've looked at in terms of assessment isn't limited to an area 4 times the size of the Mary River mine that you see denoted with the black stripes. I'm not sure that the assessor turned his mind to what lands were demised or not. I think that's something that might be best directed to Council to GN to understand better what approach they took.
certainly, yeah, no, certainly. I'm just trying to appreciate Baffinland's perspective on this.
Right, no, for sure. And as I stated, our position is that there is an area that has been demised. It is the impact area and the exploration area, and the rest of the areas that are set out in the lease, and in particular, the general areas are accordingly, in our position, simply not subject to tax.
The impact area and the exploration area, these are the areas where the lease provides Baffinland with exclusive possession.
That's correct. And there are activities that Baffinland can undertake on those areas.
Right. Okay, I understand. Thank you very much. Now, then, can we go to agreed facts number 2, please, Mr. Secretary? Council, I want to go to the part of the second agreed facts where the parties have laid out the assessment issues that remain and how the numbers tumble depending upon which way the panel may go. Mr. Secretary, how are you doing with that, sir? Okay, I don't think he's here, so perhaps could I just ask you to turn in your
Yes.
materials to that?
I'll pull them up and I will screen share so that we can all see them.
Thank you very much. I think if you're using the version that is in your FTP site, it will be AF12, paragraph 9 of the second agreed statement of facts.
I'd like to apologize. My screen is completely frozen at the moment, so I'm rebooting my PDF.
Thank you, Mr. Secretary. I think we're able to work on this while you're working on your technical issues. And if you could let us know when you're restored, we'll get back to you.
Will do.
Thank you, sir.
You should be able to see now the second agreed statement of facts on my screen. I believe you indicated.
Yep, I see it. Paragraph 9, right there.
Yes.
All right. So the this was very helpful, and I just wanted to make sure that I understood how the calculations would be affected depending upon how the panel may or may not decide.
Yeah.
So if you go to paragraph 10, I've just been questioning on that paragraph a little bit. My understanding is that your position is that the area that, if taxable, should be taxed is the impact area and the exploration area, subject to assessment would be those two areas.
Right.
Okay, I have that. Thank you. Now, in, let's say, paragraph 11,
Yes.
it wasn't clear to me if the government of Nunavut had agreed with this, or if this was part of the agreement that the parties had reached, or if there's some sort of disagreement on how non accessible indirect costs might be impacted.
I believe this is an area where there is agreement. And if you scroll down, in each case for each year, what's been done is that the calculations are done in paragraph 15, for example, what Baffinland says they would be, and then what GN says they would be. I do appreciate that the math gets a little bit more complicated if, for example, this tribunal were to rule, for example, that Baffinland were correct on the portable crushers, but not correct about the tote road, or vice versa, for example. So what I would suggest in that case is that if the tribunal does reach that result where it's not completely clear from the math on the face of the agreed statement of facts, it might simply be that easiest to go back to the parties to say and ask us to essentially perform the math. And I would note that this is a fairly common procedure followed in cases where there's complex damages and all sorts of mathematical formulas have to be applied. Because quite frankly, as a lawyer, I'm not sure I feel fully competent to do this math. And I think probably the easiest thing would be to say to go back to the assessor and Altus and get them to confirm what the numbers would be based on the particular findings of fact and law that the tribunal reaches.
Thank you, counsel. I think that responds to the questions I was trying to ask. So I appreciate your suggestion in that regard. That would wrap up my questions on the agreed facts. So you can take that down, counsel.
Mr. Counsel, I've resolved the matter.
Mr. Secretary, then are you able to pull up the expert report? I believe it's Mr. Fath that BMC has filed. It is at BIMC 403 and 404 that I'd like to have a question for clarification about one of the references there. So it would be the BIMC record at pages 403 and 404. And while the Secretary is pulling this up, just let me explain that it appears to me there's a reference to a section of the Act that that may have a typographical error in it. And I just wanted to to clarify which section is being referred to. So if you scroll, yes, it's directly at the bottom of the page there, Council. It's the very last ones. There's a parentheses 2, parentheses 2, parentheses B. And I think there might be one set of parentheses too many in there. Can I ask you to check that, please, and let us know what the correct section should be?
Yes, I believe that appears to me to be a typo as well.
That'd be helpful, thank you. And Mr. Secretary, if you go to 404, you'll see the same number of parentheses in the reference to this section under those parts of this report, number 1, number 2, number 3. They all refer to a parentheses 2, parentheses 2, parentheses B. And I just wanted to ask, please, for clarification as to what was being referred to there.
Yes, we would be happy to provide the correct reference.
Thank you very much. That can come down, Mr. Secretary. I would like to ask you about the tote road. And Mr. Secretary, it might be helpful if you could pull up the Nunavut Impact Land Agreement, please, at section 21.7.1.a, or sub A. Council, while this is being done, this clause that I'm taking you to refers to a third-party interest. And we received your submissions on that yesterday. I wanted to ask if you might advise whether the definition of third party in 1.1.1 and third party interest in 21.1.1 of the agreement, how that relates to your submissions, please.
Just give me a brief moment to pull up the relevant sections on my screen so that I have both of them in front of me.
Thank you, Council. This is just really, the clause uses terms that are defined, and I just wanted to ask for your submissions about how the definitions apply in the context of the argument that you made, that's all.
Yes. So the article, the definition in 21.1.1 of third-party interest means, for the purposes of section 21.7.1 to 21.7.6, a right granted under the Territorial Lands Act or the Public Lands Grants Act that is enforceable against the Crown, but does not include a prospecting license in respect of Inuit-owned lands held in the form referenced in subsection 19.2.1. And third-party interest includes a land use permit and a permit to prospect. In the present case, I don't believe that there's any evidence on the record of whether the third-party interest over the tote road was registered under the public lands grants. What does appear to be the case is that at the time of the Nunavut agreement, there was a existing third-party right of access over the tote road, and that seems to have been enforceable against the Crown. So in our view, this definition of third-party interest is inclusive, but not exclusive. So to the extent that there is information lacking on the record about whether this right was registered or not. In our view, it still falls within this definition of third-party interest.
Thank you. That's helpful. I appreciate that. And then I just wanted to conclude by reflecting back to you what I understood to be the gist of your submission on the principles of treaty interpretation, so that I understood it. I think I understood it correctly. Now, I understand what you're asking the panel to do is to interpret the treaty, the Nunavut the Nunavut Inuit Land Claims Agreement, in light of its context in the record,
Yes,
in order to identify the parties' common intention.
correct.
Thank you. Council, I don't have any other questions. This, of course, is subject to the process that the chair referred to earlier. Much appreciated.
Understood.
Thank you,
very
Chair.
much. Understood.
Thank you, Council.
Thank you, Kirk. Any comments further arising from those questions? Hearing none. Oh, sorry, go ahead.
No, I was going to say, I didn't know if that was directed to us, but no, we have no, or the others. We're fine.
Okay, thank you. Thank you very much. So I'll now open it up to the panel for any questions you may have. We'll start with Paula.
Hi there. So I have a preamble and two questions, I think. Okay. So just on the issue of interpretation of the Nunavut Land Claims Agreement, if we accept your interpretation of that agreement, it would mean that as economic development increases within the territory, the tax base would not increase. So if Inuit elect GN and QIA members, and Inuit are the majority in the territory, is it not fair to say that Inuit would also benefit from improved or increased programs and services provided by the GN through an increasing tax base? So that's, I believe, the first question. It looks like you have something to say, Mr. Halpin?
Yeah,
I wasn't sure if that was a question or a comment.
I could answer that first question first.
And I will have some comments too.
Okay, so my first response would be on the premise that as economic activity increases, the tax base would not increase. And that presumes that, first of all, the economic activity would be on Inuit-owned lands as designated, and that none of those Inuit-owned lands would receive local government services or improvements. I don't know if that's a correct assumption. What the evidence seems to show is that these are fairly unique lands in terms of their geographic location and what is done on them. I think there's every likelihood that as economic activity grows in Nunavut, that there will be both a variety of different types of activities taken on Inuit-owned lands and non-Inuit-owned lands, including Crown lands. The Crown continues to be a significant holder of land in Nunavut. And it's quite possible that some form of local government services would be offered to such lands. And you heard from Council to QIA on the first day that the threshold is quite low. It's not, they're not saying this provision requires a full suite of local government services and improvements to be provided to Inuit-owned lands. You don't have to have a full functioning municipal system for that definition to apply. There simply has to be some local government services and improvements provided to the Inuit-owned lands in question. So it's quite possible that even the Mary River lands themselves will, in future years, become the beneficiary of some local government services or improvements. What we're looking at is the particular years in question and what was offered during those years. So that's my first comment. Your second comment about, wouldn't it benefit Inuit to take advantage of the services and benefits that could be financed through a broader tax base? And there are sort of two responses to that. The first is that it is, of course, open to Inuit at any time to amend the agreement, the Nunavut agreement, with the Crown, so as to alter these taxation provisions. These treaties are, in some ways, like any other agreement, they can be amended. The parties to the agreement would have to amend it. But if Inuit at some point in the future determine that they would benefit from a broader tax base, they certainly have every right and every ability to go back and amend the Nunavut agreement. The second thing I would say is that at present, what we say is that what was contemplated is that these lands were, the taxation provisions in the Nunavut agreement were designed the way they were designed so that Inuit could, through their own economic activity, determine the best way for themselves to maximize their economic participation. And in this case, we see the IIBA has given benefit to Inuit in exchange for the use of the Inuit-owned lands. And it is, of course, also open to them to maximize or alter their financial participation through negotiation of different terms in IIBAs if they don't feel that they're receiving adequate compensation, or if they think that there is further funding needed. So in summary, I would say in terms of benefit to Inuit, one, they have the ability to amend the agreement. Two, there is already a mechanism contemplated, which is the IIBA. And at the end of the day, the question isn't necessarily what the tribunal thinks would most benefit Inuit, but what Inuit thought would benefit Inuit at the time they negotiated the agreement. And if this tribunal concludes that, for example, it would be beneficial to Inuit not to pay tax on Inuit-owned lands that don't receive local government services and improvements, but that wasn't the bargain struck. This tribunal is, in that case, still has to apply the interpretation that it believes the parties struck at the time of the agreement. So the question is really, what did Inuit believe would benefit Inuit at the time the agreement was struck, and what was the common intention of the parties?
Yes, and I had a couple of additional points to follow on what my colleague just submitted. I guess, firstly, the benefits that flow to the Inuit are not limited to or restricted by the tax base. As we've seen, there are significant benefits identified in Mr. Anderson's affidavit filed on behalf of the IAMC. The lease provides for royalty payments in millions of dollars. There's the IIBA, which provides as well for benefits to the communities. It's all described. And these are significant benefits and advantages that flow directly from the commercial activity at the Mary River, but are outside currently the tax base. So the benefits are there, and they're not limited to or restricted by the tax base. And the second point I would make is that the jurisdiction of this board, I mean, we acknowledge that it is, and we've invited you to consider the application of the land claims agreement and PATA in that context. But this tribunal should exercise some reserve in working too far down, figuring out how things may benefit or not benefit in the future if there's a growth in economic activity. I'm not saying you should divorce that completely from your mind, but there should be some reservation by this tribunal, stargazing down the line about what might happen with respect to future activity and how that may play out. Those are my two additional points. Thank you.
Okay, thank you. I just want to reply. So what I am suggesting is that there might be different ways of interpreting, different ways of understanding the agreement besides the interpretation that you are putting forward, right? And so that really is the gist of what I'm asking here and trying to communicate. There are other ways to understand that, and I see that as a possibility for the tribunal to interpret some other way beyond what you're putting forward.
I would only add to that if there is a third interpretation that hasn't been identified by the parties, that the parties be provided with the opportunity to comment on that interpretation and provide submissions on any third interpretation that hasn't been identified by any of the parties.
Anything further, Paula?
No, that's it for now.
Chair, could I request an indulgence and offer a comment on this question as well? Because I believe the tribunal member's question is equally directed towards QIA's position on this.
Sure.
Sorry.
Sorry, I was merely asking for an opportunity to just add a comment in response to your question about whether, as the tax base grows, shouldn't there be additional, as the economic base grows, wouldn't it be beneficial to Inuit? I think from a certain,
continue, Jeff.
Thank you. Just in response to your question, I think from a certain perspective, there could be the benefits. Taxes can provide a benefit to Inuit in the territory at large. But I would say that there is a number of risks that QIA bears as a result of this tax bill. The direct question before this tribunal is whether or not QIA should be assessed a considerable property value to begin with, and then should taxation be applied on that considerable property value. The property itself, as you've seen, is worth, has been assessed at approximately $3 million. The improvements have been assessed at approximately $180 million. QIA takes, one of their largest tasks over the last number of years has been dealing with their tenant, BIMC, on these lands. QIA, as I mentioned during our submissions, expends a considerable amount of its own human resources in managing that relationship to promote economic development on their Inuit lands, which has other impacts, including on Inuit employment, on the various benefits that are paid directly to Inuit from BIMC. And the prospect now that there's going to be a very large valuation ascribed to their Inuit-owned lands and a potential very large tax bill. I walked you through the implications of that the other day. One of the implications, of course, is that while the government cannot seize or execute Inuit-owned lands, there is very much the potential that any of those tax assessments may well come directly out of this, out of Inuit resources. Including potentially, should the potential horrible ever come to pass of BIMC leaving the territory and leaving QIA with a tax bill, that those resources will be drawn directly from Inuit. So on the one hand, I'd suggest, the imposition of property taxes could lead to additional government services that may have an indirect benefit to Inuit. The prospect here is that there'll be a direct impact on Inuit finances and on QIA's ability to carry out a variety of its own programs. And I'll say QIA offers a number of programs, including, we have these in the record, primarily in the affidavit of Stephen Bathory, a discussion of all the various programs, which I'd suggest are very akin to local government services, including daycare, training, Inuit education. QIA undertakes a number of those services and an impact on their finances. I'd suggest it's somewhat of a wash. And I echo Mr. Halpin's comment that I don't know if you need to speculate too broadly on what would be best. Our focus here has always been what's best is a proper implementation of the land claim agreement. That's the legal foundation that the parties set up to govern the Indigenous Crown relationship here. So those are my comments. Thank you very much for the question.
Thank you very much, Jeff. Any further comments, Paula? Oh, you just muted there.
No, thanks.
Okay, thanks. Okay, thank you. Rick, any questions?
Yes, I have one here. I'd like to get your interpretation of the 4 definitions of improvements in PATA. It's section 2(1), A, B, C, and D, with respect to the assessment of the crusher and the tote road.
Could we pull that up? Jenna, you're on mute. Can we pull up that section so we can all see it? Either Mr. Secretary or Jenna.
I can share my screen. So if I understand correctly, you're looking at section 2 and you're looking at the definition of improvement and then the exceptions, and you're wondering how the crushers would fit into. Okay, so subject to, so let's go through them one by one then. Section 2 sub 1, everything that without special reference would be conveyed if the real property were sold. So typical, I think what this reference is what we would call as lawyers fixtures. So that would include things like typically that would be sold if you sell a property.
Like a house or a building, you know, that's
right. So for example, fencing would be an example. If you buy a piece of land and there's a nice fence on it, you assume you're getting the fence unless it's specifically excluded. I don't think that applies to the crushers. I don't think that someone who bought the mine, or in this case, the rights to conduct the mining, since we know that the fee simple interest lies with the DIO, I don't think that they would expect the crushers to be conveyed unless there was a specific reference to them in that agreement. 2 sub 1 sub B, everything fixed to land even slightly unless there's evidence showing that it was intended that the thing was to remain separate from the land. So what you'll have seen with the mobile crushers is that they're mobile, they can be moved on wheels. But more importantly, there is evidence that the thing, in this case, the crusher, was intended to remain separate from the land. We have the affidavit evidence of Mike Armstrong. We've got the evidence that says that these are going to be removed as part of Baffinland's reclamation obligations, even though some things will remain. There's evidence that even now the crushers are being moved and in some cases removed, depending on the particular status of mining development at the mine.
I'd like to add to that too. I think the record will show that the crushers are not fixed to land. The crushers there's pictures of the crushers in the affidavit referred to or contained in the affidavit of Michael Anderson from the manufacturer of the crushers. And they're formally described as portable crushers. The proper name for these crushers, although my colleague said sometimes they're called mobile, sometimes they're called portable. The fact is that the manufacturer calls these portable crushers and highlights the portability of these crushers. It's fancy machinery, but they're on wheels. They're intended to be portable. They are in fact portable, and they are moved. They are moved around. The record shows they're not fixed to land. They prepare a little pad to even it out because they work, and they like any heavy machinery. If the land is unlevel, it'll upset the hydraulics and all of that. So it's important that it be level. So they'll prepare a pad, but that's just a pad on the ground. These are not fixed. We submit in any way to the land. and certainly, the clear intention is even if there was some temporary fixing to the land, which we don't believe is anywhere suggested in the record, these things are clearly are intended to remain separate and are in fact separate and are moved around. So Janice, sorry, continue on 2C. You're on mute.
So 2C is any machinery, equipment, appliance, or other thing forming an integral part of any activity on or use of land other than a residential use or activity, whether or not that thing is mobile. So this captures machinery, equipment, appliance that forms an integral part of a commercial use or activity of land. So the question then becomes, what does integral mean? I would submit that integral doesn't simply mean important, but it means an inextricable part of. In this case, we have evidence from Mr. Anderson, who says that these pressures aren't really a core part of the mining activity on the land, because unlike mines, for example, Agnico Eagle or some of the other mines where they're trying to extract mineral from the aggregate, the crushing is really sort of a bit of an afterthought. It's something that they do to make transportation a little bit easier. It's something that they will do at different locations depending on their setup at a given time. And in our submission, that does not meet this high threshold of integral. It's not essential, is not a core part of the activity or use of the land, which is mining.
I have something to add to that too. Mr. Anderson, when cross-examined, explained the difference between what they do. He says, I don't know if you can pull that back up, Jenna. We've lost your screen share or whatever. But you're on mute, Jenna. The activity says that this iron ore is so rich there, you just scoop it out. Unlike, and it's like basically 100% iron ore. I mean, that's the beautiful thing about this opportunity. Unlike gold, and he drew a clear distinction between gold ore, which is you have tiny little veins or flecks of gold, and you must extract the gold from the gold ore, the rock surrounding it, by crushing it. And that's how you extract the gold ore. This is not that case at all. This is 100%, and you scoop it out. And he was very clear. He says, we crush it for two reasons. To currently, and this is only currently, to currently facilitate transportation because they truck it to the mine along the tote road. And for marketing purposes, he says, because our clients like to have it a particular size for their own needs because it goes into smelters and that sort of thing. So we crush it currently for transportation, and secondly, for marketing purposes, what our client needs. He said, and once we get the rail set up, assuming that happens, the crushers get moved. We're not, because the rail presumably can handle bigger chunks and takes away the need to crush the 100% ore. And he says, and if there's a crushing, it'll take place down by the port. So to extract it, and the activity could continue without the crushing. That's very clear based on the record. The extraction of ore from the mine itself, the mine proper, can take place without the crushers. It's for transportation and marketing purposes, and is going to be moved if and when the rail gets set up.
And just jumping back to counsel to the tribunal's question respecting the typographical error in the expert report, I can confirm that the correct citation is 2.2 sub B, being this provision here. So going back now to definition of improvement, I believe now we're on item D. So this definition, it captures anything forming an integral part of the things referred to in paragraphs A to C, unless there's evidence showing that it was intended that the thing was to remain separate from the improvement. So this includes anything forming an integral part of something that would be conveyed if real property were sold, an integral part of everything fixed land, unless it's shown that it's intended to remain separate, and that anything that's an integral part of machinery, that's an integral part of any activity on use of or on land, unless there's evidence showing that it was intended that the thing was to remain separate from the improvement. And so in this case, we say, first of all, it doesn't, the structures aren't an integral part of anything in A to C. And in any event, there's evidence that shows it was intended to remain separate from the improvement. In that these are temporary crushers, they're moved from time to time, they're moved to different locations, and Mr. Anderson has indicated they're going to be removed as part of the mine's reclamation obligations at the end of the mine's life. So then to have the full understanding of that, you then have to back out of those definitions all the exceptions that are set out in subsection 2.
Is that helpful to you?
Yeah, that's fine. Thanks.
Okay.
Any further questions, Rick?
No, that finishes it.
Okay, thank you. I have a couple questions, and forgive me. Some of them I just need some clarity on some of the terms used as part of my questions. But first, I'll start off with the tote road. So, I mean, there's no dispute the tote road's there. It exists. It's primarily used for transportation to the port. But am I understanding correctly, and I asked this to both Matthew and Jenna Ann, do I understand correctly that your position is that it should be exempt from an assessment because it is granted a public right of access? And the second part to that is QIA spent a lot of time talking about the practicality of the definition of local government services and the fact that Mary's River Mine is so far removed from the jurisdiction of a municipality that in keeping in that mindset, because this tote road is kind of in the middle of nowhere, like it was described as being, it is primarily there for the mine. So what I'm trying to get my head around is it only free of assessment because of the quote unquote public right of access? That's my question.
Right. So the reason we say that it's exempt from taxation is that it is in essence, a public road. And it's true that Baffinland is the primary user of this road at present, but there is a right of the public to use the road, and it is enshrined in the Nunavut Agreement. And yes, you are correct that the reason we say that it is exempt from taxation is because of the public right of access to the road. In terms of this public right, and as you note, it's in a remote location. It's primarily used by Baffinland, but the reality is that if there were another company, for example, that set up operations in this vicinity as well, they would have an equal right under the Nunavut Agreement to also make use of this road. And so in such a circumstances, the inequity can be seen of taxing Baffinland for a road that is used by other members of the public. Now, at present, as noted, it is Baffinland that is the primary user, but the fact remains that it's open to the public and anyone can use it.
Yes, and just to supplement that, I mean, it's because the tote road has been around since the 60s. It predates Baffinland. It used, it predates the Nunavut Agreement. This was all Crown land. And once the Nunavut Agreement kicks in, as my colleague identified yesterday, this right of use, this road, is picked up, is because it's on Inuit lands, is picked up by the DIO, and they then acquire the crown rights, and the crown is exempt. So that's there's a number of dots to connect, but my colleague took you through that yesterday, and it's set out in our fact. And the bottom line is it's a public road. It's formally recognized as a public road in the lands claim agreement, in the lease, and by everybody, and is in fact used as a public road. So the bottom line is, yes, because it's a public road and predates Bafland's presence in the area and the lease, it is exempt. And quite right, as my colleague said, this is a public road, and if some other mining operation were set up around the corner and start to use it, you've got this strange situation that it could have Baffinland paying through the QIA for these improvements when its competitor is driving on this public road for which we're responsible. So thank you.
Okay, thank you. And I think then my next question, I think Jen-Ann, you might have answered this in your explanation to Rick. So I'm clear on, and this is in respect to the crusher. So I'm clear on, the difference between mobile, portable, and being affixed to land. I'm clear on that. But also, I think in terms of building access to a mine, although it's not the primary function of the mine, I think it's integral to that mine, that it obviously has roads to access from high water mark to the site. And I may be wrong, so I'll let you correct me if I am. And that's my thought in terms of integral. But even if it is, if I understood your answer to Rick, I think it was PATA D or C or D, where you said that even if it is integral, if it wasn't meant to be a part of the permanent setup, then it would be exempt. Am I getting this correct?
So let's just pull up the sections again. So let's pull up what we're looking at. So we've got So actually, I'd like to address 2 points. I agree with your comment that building can be an integral part of mining activities. But what we're saying is that the use of these crushers, they're not even integral to building. They're an aftermarket add-on, if you will, to ship the ore more conveniently or to meet client specifications. And it's not something that needs to be done on the site. It is for convenience, but it's not something that is a must-have for the mine to operate. In terms of whether something can be an improvement if it is integral but not meant to be, but it is meant to be separate from the land. So different sections have different requirements in that respect. So if it's fixed to the land, and if there's evidence that it tends to remain separate, then it's not an improvement. If it's machinery, equipment, appliance, or other thing, then and it forms an integral part of any activity or use on the land, then it can be an improvement, unless it falls under the exception in B, which is for personal property, including vehicles or any machinery, equipment, appliance, or thing that is portable, except as provided under paragraph 1C or D. So if we're looking at machinery, if we're looking at C, starting point for improvement is that if it's integral, then it is an improvement. But if it falls under 2B, so if it's personal property, meaning, well, I believe there's a definition of personal property, which we can look at in a moment, but it would include vehicles or machinery, equipment or appliances that is portable, then it is not an improvement. So it does get a little bit circular And it's important to note the definition of personal property, which I believe is up here. I'll have to double check location. But personal property typically means property that is not real property. And so it does become a somewhat circular definition, but if it falls within the exception, then it's not an improvement, even if it otherwise would be.
Okay, thank you. The last question, and it's to either Matthew or Jenna, is I don't understand, I'll be honest with you, I don't understand the term demised as you've explained it to us. And could you explain to me the term demised, how it's used, and why you think it's relevant in your argument yesterday and today?
Right. So the starting point, as always, is the Nunavut agreement. And what the agreement says is, let me just find Article 22. The starting point is that no tax, federal, territorial, provincial, or municipal charge, levy, or tax of any kind whatsoever should be assessable or payable on the value or assessed value of Inuit-owned lands. Then there are exceptions. So outside municipalities, Inuit-owned lands on which improvements have been made shall be subject to real property taxation of laws of general application. So the question is then, well, if there's Inuit-owned lands where improvements have been made, we know some of these parcels are quite large. Is it the entire parcel of Inuit-owned land, or is it something else that becomes subject to tax under Article 22.2.3? So the next section goes on to say that notwithstanding where an improvement has been constructed and an area of land for that improvement has not been demised, the assessor may assign an area no greater than 4 times the total ground area of the improvements. So what we understand this to be saying is that if you have, say, a parcel of Inuit-owned land that's 1 million hectares, and there is a store on 1 hectare, the entire 1 million hectares does not become assessable. What becomes accessible is an area 4 times the size of the improvement. So in this case, if the store is on 1 hectare, then 4 hectares is the maximum amount of the Inuit-owned land that is accessible. That's if there hasn't been land that hasn't been demised for that improvement. So then demise is not defined in the Nunavut Lands Panel Command. So we have to look at what the common law definition of demise is. And looking at that common law definition, what we see is that demise is a term used to denote the assignment of rights to a leaseholder, who's the party that holds the lease in a land. And it means that a certain bundle of rights has been given. So there are certain rights that are associated with being the owner of the fee simple interest. There are certain rights associated with being the leaseholder, owner of the leasehold interest. And in the case of lands that are demised to the leaseholder, what that means, we say, is that they've been given a right of exclusive possession, and they can use those lands, in this case, for the purpose of that improvement. What we see when we look to the commercial lease between QIA and Baffinland is that the general areas have not been demised for the improvements. So the improvement is the mine and the various structures that are associated with the mine. And what we say is that there is an area of land that has been demised, that has been given to that land to be able to build the structures on. And that's the exploration areas and the impact areas. And that's the area that's been demised for the mine, not this whole parcel of Inuit owned lands, some of which QIA has no right to carry on any activities on other than reclamation monitoring. So what demise means is you've been given this bundle of rights, you can have exclusive possession over it, you can carry out activities on it. And what we say is that what has been demised is set out in the lease. And when you read that, 22.2.3, that says what happens when there isn't an area that's demised, I think what you have to do is look at, well, the question that arises from 22.2.3 is, if it says where an area of land for that improvement has not been demised, this is what you do. I think the implication is that when an area of land has been demised for that improvement, the area of land has been demised for the improvement. And again, going back to the previous sentence, the idea is that if you have a parcel of Inuit-owned lands and only some of them have improvements on them, the whole package of Inuit-owned lands doesn't become taxable. It's just the part with the improvement. I hope that clarified it a little bit. I realize it's a difficult concept to work with.
No, that was very helpful. Thank you very much.
And just to complete the thought on that, I mean, demise is a sort of grant of interest in land, Lieutenant. And while the commercial lease purports to grant something, it effectively doesn't grant anything. We say demise in the usual context when the tenant grants exclusive possession or in some cases non-exclusive possession, but it grants certain rights. And the lease clearly says, well, we grant you some rights, we also take away all your rights. You can't do anything. There's no activity. You can't use the land. You can't do anything on the land. And as a matter of fact, you don't even pay any rent for the land, right? So we really, if you look at the substance of whatever conveyance was made to Bafland for the general areas, the substance of it completely denudes any real any interest given to Bafland. And Mr. Anderson in his affidavit sort of alludes to this, and I'll just refer to his affidavit. There's no need to pull it up, but it was really sort of almost, and I'm going to paraphrase because I haven't read it in a while, but almost an afterthought or for convenience purposes not to break up the parcels. In his affidavits, we appreciate the QIA may have a different recollection of that, but that was Mr. Anderson's affidavit, and he was involved in the negotiation of the lease. It was almost included as an afterthought not to split up the parcels, I believe is what his evidence was on that. So it's really an empty interest when one looks at the substance of the rights granted and not granted to Bafland. Thank you.
Okay, so thank you both Matthew and Jan. Thank you very much for your answers. I think that concludes the questions from panel and our council with respect to your presentation. I think we're ready to move on to the GN and Jane O'Neill and Ryan Baxter. Prior to that, did you want to take a quick 10-minute break? I'll give Jane and Ryan a chance to set up, and then we can come back. So I've got 9:35 local time, so 10 minutes from now.
And just before everybody leaves, this is only for Mr. Lambrecht and Mr. Silva. Did you get our PowerPoint by email? Not sure you need it because we can run it from here.
I did get it, yes.
And just to confirm, all I have to do is share my screen?
Yes.
Thank you.
Yes,
Okay,
and to respond.
Sorry, go ahead, Gert.
I'm sorry, Mr. Chair. My legal assistant is in the we did receive your PowerPoint presentation by email.
Okay,
My legal assistant has added it to the tribunal record and is in the process of adding it to the FTP sites. I think confirmation that it is in your sites will come out shortly.
she is efficient.
Okay, thanks, everybody. Quick 10
Thank
minute
you.
break and we'll all be back. Please turn your screens on when we come back so we know you're here. Thank you.
Excellent, thank you.
Well, welcome back, everybody. I think we've got everybody back. So I would like to welcome Jane O'Neill and Ryan Baxter to present on behalf of their client, the government of Nunavut. Go ahead, Jane.
Thank you, Mr. Chair. To start off, I want to thank council for each of the appellants for having done such a thorough review of the applicable law in the case, and the benefit, of course, of going last is that I won't have to go through all of those principles again with the panel. They've been thoroughly canvassed. We all agree what the principles to be applied here are. And I'm sure that the panel is now well-versed in the law of statutory interpretation and treaty interpretation, which is what this case, in essence, is all about. Secondly, I understand there are thousands of pages in the record, and I appreciate all of the efforts, Mr. Chair, you and your panel members and council have put in reviewing all of that. But today, I want to let you know that we don't think, with the exception of background, which everyone needs, there's one very important document before the panel to review, and the answers to the question, at least on the threshold issue, are within the four corners of that document, and that's the land claims agreement. Now, I will be addressing what I call the threshold issue, is whether these lands, the Mary River lands, are assessable and taxable at all, given the provisions of the Nunavut Land Claims Agreement. And my colleague, Mr. Baxter, will be addressing what I call the more technical issues relating to the tote road, the crushers, and the actual surface land to be assessed. Well, before I start, there are a couple of, I don't want to call them myths, but a couple of points that have seemed to come out a number of times through each of the appellants that I want to address at the outset. And I heard a number of times, and I hope wrongly, that the appellants suggest that if in this case, the Mary River lands are found to be taxable, that as a result, all Inuit-owned lands will be taxable, assessable and taxable. I'll use those words interchangeably, but I mean the same thing. And that's simply not the case. We know that no Inuit-owned lands have ever been assessed or taxed unless they contain improvements. And that's why we're before the tribunal today. So that is not a result of a decision in favor of the GN. The second issue I wanted to address at the outset is this doomsday scenario that in particular QIA has been putting forth. Well, what happens if BIMC flees the jurisdiction bankrupt and they're on the hook for any property taxes relating to the property? Well, to say that is to sort of undermine this long-term project that everyone has faith in. But secondly, it's also it fails to recognize that QIA is a sophisticated commercial negotiator who, demonstrated in the commercial lease here, has already negotiated that BIMC is responsible for all property taxes that may be levied on these properties. If there's a concern that BIMC could somehow leave the jurisdiction and leave them with the bill, Well, it's certainly open to QIA to require under the lease for BIMC to provide them with a reserve to cover property taxes. So I think that doomsday scenario shouldn't play any role in these proceedings at all. Either these lands are assessable and taxable or they're not. So just briefly to review the argument we'll go through. And I'll preface that with saying that even though we do have a huge record here, I don't see the issue for the panel to decide as that complicated. But there are a couple of areas that I think I want to cover just basically before I begin. So first, I'm going to review property taxation in general and the provision of local government services in Nunavut. And as we know, the territorial government's the taxing authority throughout the general taxation area. The territorial government provides all local services to the general taxation area, and all taxes collected in that area go to fund local services. I heard my friend saying, well, we don't know where this money is going. Well, I can assure you that the money that's expended by the GN on local services in the general taxation area far exceeds any property tax collected in that area. And I'll show you specifically through the financial documents that are publicly issued by the GN how local services are funded.
Jane, your slides aren't advancing.
That's because I wasn't advancing it.
Oh, I see. Well, that makes a lot of sense.
I am now. How about that? So the key documents. As I said earlier, the threshold issue can be determined within the four corners of the land claims agreement. We don't have to look at PATA. That is where the threshold issue is decided. And once the threshold issue is determined, then Mr. Baxter will take you through the relevant provisions of the Property Assessment Taxation Act. So our position on the threshold issue is that the starting point under the land claims agreement, and we're focused in particular on Article 22, is that the starting point is that the agreement prohibits taxation of any kind. Are these advancing now? Ryan? I'm sorry.
I just sent a note to Bruno on my screen, Jane. I can't see. It just said, oh, there we go. We're good now. Yeah.
All right. So again, so the threshold issue, the starting point for the tribunal is that the land claims agreement prohibits taxation of any kind on Inuit-owned lands, whether it be federal, whether it be municipal, whether it be territorial. There's a blanket prohibition on taxation of these lands. But there are two exceptions to that. And that is when you have Inuit-owned lands within a municipal boundary that have improvements, and I'm paraphrasing here, I'll take you later to the exact wording, that have improvements or are available to be developed. In essence, they've been subdivided or they're in a planning area where they can be developed. The second exception, which is the one applicable to the tribunal's decision, is Inuit-owned lands outside municipal boundaries that have improvements. And that's what we say we're dealing with now. So that brings us to what is the key question on the threshold issue that the tribunal has to answer. And that is, what does the definition of real property taxation in Article 22.1.1 mean in the context of the land claims agreement? Now, my friends have parsed words and, put meaning and emphasis on particular words in that definition of real property taxation. But the position of the government of Nunavut, and one we ask the tribunal to accept, is a common sense definition. Real property taxation, that's a standard definition. Everyone understands that it's tax assessed on land and improvements. It's taxed by the authorizing authority, and for the most part, it's used for local services. It's certainly used for public services. For those of us who live in a city, generally it's the municipality who's taxing our land and improvements. If someone has a remote cottage, depending on the province or the territory you're in, that taxation might come from the province. But simply because you're in a remote area and you might have your own well and go by a lantern, doesn't mean you're not paying property taxes. Certainly levels are different in different areas, but we all pay property taxes. And generally, and maybe I could even say always, real property tax is used to fund local government services. It's not a magic definition of real property taxation that's contained in the land claims agreement. So in the general taxation area, all local government services are funded by the GN. How are those funded? Through real property taxation in that general taxation area, and as we will see, other influxes of funds. Now, I think we can all understand as well that the amount of property tax collected in the general taxation area doesn't determine what services a particular parcel of land will receive, and is not dependent on what services a particular parcel of land uses. So, for example, you may have a community that is half the size of another. So the tax base there, obviously, is going to be lower. But that doesn't mean their services are going to be any less. And it doesn't mean that, for example, in the larger community, if there's a community center located there, but there isn't one in the smaller community, that the larger community is going to be required to contribute more. I think we can all accept that property tax, just as a general rule, is an indirect tax on wealth. It's a way to distribute so that services can be evenly distributed and those who have more pay more. It's not dependent on the service you receive. It's not open to a person to say, I don't want your water, I don't want your sewer, I don't want your schools, I'm tax exempt. Now, assuming that these lands are taxable, then Mr. Baxter will go through the technical issues and demonstrate that the tote road and associated works are included in our improvements. The same with the crushers and the related equipment. and that all of the lands under the commercial lease are to be assessed, not just those parts containing improvements. And in that, he will explain that the way that property is assessed by the assessor is by parcel. And we have particular parcels of land that we're dealing with. So what use is being made of any little piece of that is not relevant to the determination that the tribunal has to make. So let's go back to the very basics. What's property tax? Simply tax based on the value of property owned. Generally, it's based on the day's value and not necessarily the purchase value. But there's more than one type of property tax. We have land taxes, improvement taxes, we have personal property, and we have intangible property. So simply using the word property tax doesn't get us to where we need to go. Real property is a term that applies to land and immovable property on land. So what's real property taxation? It's tax on land and immovable property, or in other words, improvements. What is it not? It's not just land. It's not just improvements. It's not personal property, and it's not intangibles. And when I say intangibles, it's simply a legal term, and I guess in the property context, it may often come in when you're valuing a commercial property. And you'll have the value of the land, you'll have the value of the building, you'll have the value of the fixtures, but the intangible part is perhaps if it's a commercial operation, whether it be, you know, a McDonald's or a Wendy's, it has some goodwill attached to it. So that's what I call intangible, which is not relevant to the issues we're dealing with, but just to say what that term actually means in practice. And I think everyone is now comfortable with the fact that there are two types of taxation areas in Nunavut. We have the general taxation area and the municipal taxation area. Currently, the only municipal taxation area is Iqaluit. Everything else is in the general taxation area. Two taxing authorities. We have the municipal taxing authority, which is currently and in practice only Iqaluit. And then we have Minister of Finance for the general taxation area. So the Mary River lands are located in the general taxation area. So the taxation authority is obviously the territorial government. So the assessable property for taxation in Nunavut is any land, improvement, mobile unit, pipeline works, or transmission lines that is liable to assessment. Where does this money go? In the municipal taxation area, directly to the municipality, benefits the residents of Iqaluit, funds local services. And I'm not saying it's limited. The local services are limited to that funding by any stretch, but. And in the general taxation area, the money goes into the general revenue. Who does it benefit? The residents of the general taxation area. What does it do? It funds local services. Now, I want to take you to the affidavit of Mr. Towns. And I'll try and pull it up here. Yes. So at the affidavit of which begins at GN3, you'll see that exhibits Z, and I think you can see my cursor as I go. Yes, exhibit Z through double D are the publicly available public accounts for the GN. And I want to take you just, for example, to one of them at page 1123. And what we're looking at here are your standard financial statements. This is the Government of Nunavut public accounts, year ending March 31, 2017. But what I want to draw your attention to is the list of revenue going into the Consolidated Revenue Fund to the territorial government. And you'll see this up here in the top left-hand corner. It's listed in thousands. So add 3 zeros to any number you see. So revenues generated by the Government of Nunavut. And these would include revenue generated through taxation in the general taxation area. Property tax. So you'll see the actual and this is just, for example, if you wanted to go through each of the years, you would see similar numbers. Property tax collected, 6,257,000. 2016, property tax, 5,005,047. So that's sort of the tax base of that area currently, or in those years. Now, and again, each of those are appended to the affidavit of Mr. Towns. How are local services funded in that taxation area? Number one, what we just looked at, property taxes collected from that tax base. And secondly, obviously other sources of revenue, because the property tax collected is not nearly sufficient to cover the cost of operating and providing local services. Now, again, appended to the affidavit of Mr. Towns are, and you'll see here at exhibits double E down through double I, they're the Government of Nunavut business plans, again, publicly available. And just in general terms, these business plans set out what the budgets are for each of the departments, each of the types of expenditure. And I'm going to take you to, as an example, and again, if you look through the various years, you'll see similar. So I'm going to take you to at GN 2199, which is Okay, that number is wrong, but but I am going to take you to, it is the Business Plan, Government of Nunavut and Territorial Corporations 2017 through 2020, as an example only. And I just want to show you the cover page if I can. And in particular, I want to show you the expenditures for local government services. And this is beginning at GN 2123. And you'll see here, it sets out what is expended by the GN for local government services. And you'll see there the various years, anywhere between, you know, almost 24 and 25 million. And then you have municipal transfer payments in addition to that, to the tune of 60 million. So if you go back to our tax base of 6.5 million from there, I think it would be very hard pressed for the appellants to suggest that they would not be assured that any taxes collected in the general taxation area from the Mary River lands wouldn't go to local services. Now, the types of expenditures that are under this heading and here it's described local government services, the exact words that would track the land claims agreement language. And various things that are absolutely understandable to anyone, a layperson, on what they understand real property taxes for and what local government services are. So we've got things like community development, planning, tax relief for senior citizens, funding for the Association of Municipalities, water and sewage, community transfers, sports and recreation, emergency management, search and rescue, infrastructure, to the total tune of 85 million. And that's similar in all of the business plans if you choose to go through them. So here, this slide is just capturing what I had showed you before on local government expenditures. Oops, I don't know how to go back. Anyway. Right, there we go. Local government expenditures, municipal transfer payments. So the cost of local government services, it far exceeds the tax base in the general taxation area. And as I suggested at the outset, the tribunal is being asked to interpret, first off, the land claims agreement, and secondly, PATA. There's no dispute at all between the parties on what principles have to apply. One principle: the words of an act, or in this case, a treaty, are to be read in their entire context and in their grammatical and ordinary sense harmoniously with the scheme of the act. I cannot tell you how many times I have cited that to a court or a tribunal in my career and don't really yet know what it means. It's one of those things where you sort of know it when you see it. So the job of the tribunal is to try and make sense of the wording in the land claims agreement, in the broader context in which it sits, but understanding that, you know, there were certain things in people's minds when they chose the words they did. And that's why we have the sub-principles, like if you have a word used and a slightly different word used, then they must mean different things. Or if you use the same word twice, it must be the same thing. Those kinds of little tips are used to inform this general principle. And what the GN is asking the tribunal to do when interpreting the land claims agreement here is to, number one, understand that these were sophisticated parties negotiating this over a number of years. And so it's negotiated with the federal government and with the community groups, and what they came up with was a comprehensive agreement meant to cover everything. Whether there'll be amendments in the future, we can't know. But the idea was to have a harmonious document that could govern the relationship of the Inuit to these lands. One very important principle we can never forget is that a land claims agreement is almost like the Constitution. It trumps any legislation. And that's why I think that in doing the analytical exercise that the tribunal has to do, I think it's safe to put PATA aside until you're comfortable with your interpretation of the land claims agreement, because it doesn't matter what PATA says. No matter what PATA says, the land claims agreement is going to trump. Now, I'll get to this in a moment, but my friends suggest that there is some conflict between PATA and the land claims agreement. But on behalf of the GN, we don't see a conflict. We see them, they're in harmony. Now, we know that the land claims agreement was brought in 1993. We know that Nunavut brought over the NWT statute in 1998, which is PATA. So to suggest that when the land claims agreement was being negotiated, that PATA was in the background, it was in a sense, because it was the law of the territories, but it certainly wasn't Nunavut law, because Nunavut did not have that law, or didn't have any. So I think putting PATA aside is useful in trying to keep our minds within the four corners of the land claims agreement. There are also a number of facts that are not in dispute. And, you know, to be frank, this is not a fact-finding exercise for the tribunal. The parties agree on what the facts are. The disagreement comes to what those facts mean in the context of the land claims agreement. So we know with certainty that the Mary River project's located on Inuit-owned lands. We know that it contains improvements. We know that it's subject to a commercial lease, at least the surface of the lands, between QIA, and I can correct that, QIA and BIMC. We know that the commercial lease contemplates property taxes. Now, my friends seem to suggest that the GM was relying on that provision of the commercial lease to inform the interpretation of the land claims agreement. But that's not what we're trying to do at all. We point out the fact that property taxes are covered off in the commercial lease because it certainly must have been something in the minds of each of the parties when they negotiated that lease. And the decision that they came to, or the agreement that they came to, is that those taxes were the responsibility of the lessee, which is BIMC in the circumstances, not QIA. So again, we're not relying on it to say this is how you should interpret the land claims agreement. The land claims agreement stands on its own. But the parties have provided for this specifically. We know that no property taxes are paid for the land or improvements at the Mary River project, even though we have assessments of land to the tune of 3 million, improvements around more than 85 million. No property taxes at all are being paid in this commercial activity, not being paid to the GN by either QIA or BIMC. The GN recognizes that there are some contributions being made by BIMC that can benefit the communities in that general taxation area. But there is no contribution at all by way of property taxes to local services in the general taxation area. Now, Ms. Madden brought up a very good point earlier when BIMC was making its presentation, and whether it was a point or a question, I don't know, but we have got incredible commercial activity happening on the Mary River lands here with no addition to the tax base at all. And as we get to, when we get to looking at the specific wording of Article 22, it's the GN's position that that is never what was contemplated. What was contemplated is that these lands would be Inuit owned and managed, and everyone would work hard for commercial activity, which would benefit QIA, which would benefit the communities around, and in turn, the entire territory and all Inuit. It was not contemplated that there would be no tax base growth in all of those Inuit-owned lands. What was contemplated is that Inuit-owned lands on their own would not be subject to taxation. But when it falls within one of the exceptions, that's when they can be taxed. So there was a bargain struck. Now, my friends referred to Section 5 of PATA, which I wanted to leave aside until we're through with the land claims agreement, but just to say, so as you recall, Section 5, in essence, says what is accessible, and that's all lands, everything, unless it falls within one of the exceptions set out in Section 4. Well, under PATA, if the land claims agreement did not exist, then all of these Inuit owned lands would be taxable. But they're not. They're only taxable if they fall within one of the two exceptions set out in the agreement. So the GN asks that as you deliberate as a tribunal, that you constantly keep referring back to Article 22, because that is the key to this decision that you have to make. And it's an important decision. And it is a decision, I agree with QIA, that will affect things going forward. It's the first time the decision's being made, and it's been entrusted to this panel. And the question is there ever a circumstance where Inuit-owned lands are subject to property tax? If you look at the general proposition in Article 22, the answer to that is no, never. Because it says, and leaving aside subject to, no federal, territorial, provincial, or municipal charge, levy, tax, any kind whatsoever shall be assessable or payable on the value or assessed value of Inuit-owned lands. And it goes on, and without limiting the generality, no capital, no wealth, no realty, no school, no water, no business shall be assessable or payable on the value or assessed value of Inuit-owned lands. That was part of the bargain. We will not, these lands will not be taxed. And also part of the bargain, there are two minor exceptions. First, Inuit-owned lands within a municipal boundary that have improvements, or, I'll paraphrase, can be improved. And that's, it's in an area that it can be developed. It may well be vacant currently, but it can be developed. That will be assessed and taxed. So it's subject to real property taxation. Exception number 2, which is most relevant to the tribunal, is Inuit-owned lands outside municipalities on which improvements have been made. The Mary River lands are outside of municipality, and everyone agrees that significant improvements have been made. Now, you'll see from the affidavit of Mr. Towns, who has been the assessor for decades, the Mary River lands were never assessed until 2014. And that's because improvements appeared on the lands. So the bare lands themselves were not assessed or taxed, but when there were improvements, rightly, the government of Nunavut looked to this provision and said, well, it's Inuit-owned lands outside of a municipality on which improvements have been made. It's time to assess and to tax. There are exceptions to the exceptions. So if there are improvements, either on municipal lands or outside of a municipality, certain improvements cannot be assessed or taxed. Improvements from government or public activity, outpost camps, any non-commercial structure associated with wildlife harvesting, cabins, camps, tent frames, traps, caches, and weirs, any non-commercial structure associated with any other traditional activity. Now, it's the government of Nunavut's position that this was very deliberately put into the land claims agreement, recognizing that any Inuit-owned lands that contain improvements are subject to tax. It's not tied to whether you have water and sewer. It's whether there are improvements. It's hard to imagine a parcel of land that contains only an outpost camp that would be subject to real property taxation except for this provision. And to say otherwise is just, my friends seem to suggest that you must have a connection to what they define as local government services, sewer, water, fire, to be taxed, regardless of whether or not there are improvements on the land. Well, if that were the case, why would you exempt outpost camps as an improvement? Under the appellants, and both of them under their reading of the land claims agreement, that would never have been taxed anyway. So back to the critical question for the tribunal that will, in essence, determine the threshold issue. A lot has been said, and a lot of it is, frankly, it's background, absolutely necessary in order to make the decision. But the appellants make much of this definition. And but for this definition, they wouldn't have an argument. They accept that if Inuit-owned lands contain improvements, they're assessable and taxable. But they want to put a caveat on it. They want to say, well, yes, however, the parties to the land claims agreement made up a special definition of real property taxation that means something other than what the rest of us all understand it means. They suggest that it means, okay, Inuit-owned lands with infrastructure are taxable only if that particular parcel of land draws on local government services, whatever that means. And they seem to rely on a proximity argument, saying the closest community is over 100 kilometers away. Well, how close is close enough? What is a local government service? If one of the neighboring communities were to decide to, provide fire patrol once per week, is that a local government service all of a sudden? I don't think that the drafters and the parties to the land claims agreement intended for this to be parsed and each word taken to mean something else when it was drafted. This is an agreement that is quasi-constitutional to stand the test of time. And the way the government of Nunavut reads it is, well, real property tax. It's like any other real property tax. It's used for local government services. Can be contrasted with, say, a deed transfer tax, which we know when the Inuit-owned lands were acquired, they didn't have to pay a transfer tax of any kind. Other kinds of taxes on real property exist. They may be, water levies or school levies or all of those kinds of things. Those don't have to be paid. But real property tax, in the normal sense of the definition, does have to be paid. Now, having added the words for local government services or improvements, including for schools and water, doesn't make the definition any different than we would understand it to be in any other context. It does not say that the parcel of land must be drawing on local government services. All it is defining what real property tax is. And we can find comfort in the fact that your age-old basic definition of personal property is right underneath. Chattel is real and personal, including all shows as an action. So our submission is what is intended here is to say, okay, this article deals with real property tax. And a few slides back, real property tax is land and improvements. Personal property, that's different. So to suggest that there is some caveat in here that makes this definition different than the basic definition of real property tax is to attempt to twist and to make it more complicated than the drafters and the parties to the agreement ever intended. Now, again, this is to stand the test of time and is to provide certainty for all going forward. What certainty is there in? Well, yes, we agree that there are improvements on this land. However, some tribunal is going to have to be constituted to determine if we use, and when I say we, I mean whether this parcel draws on local government services or not. Surely that was never the intention. Even on a plain reading, real property tax imposed for local government services. A few slides above, we looked at the GN's expenditures and revenue. Our taxes that are gathered and collected in the general taxation area imposed for and used for local government services? Of course they are. Real property tax outside of Nunavut, outside of the land claims agreement, outside of, come and sit here in Halifax. My real property taxes are used for local government services. And that's why they're imposed. That's the purpose, the very purpose of real property taxes. It's an indirect tax on wealth for the greater community. That's what real property tax is. It's not to go for federal funding of programs. It's not to go for funding for a municipality outside of my province or my territory. It's always used for local government services. So there's no magic to using the word local. And again, when we look at the exceptions, so if you have property within a municipality, then we might as well assume that any taxes that are being levied on that property are being used for local services. So what's to say property outside of the municipality is any different? They're treated the same way. If there are improvements, they're assessable and taxable. And not to be repetitive, but the exceptions to the exceptions help inform. There are exceptions to the exceptions. So if we've got Inuit-owned lands and you've got a parcel upon which there are improvements, obviously outside a municipality in some of these subsections, then the parties put their minds to specifically exempting them, those parcels and those improvements, from taxation. And that is in accordance with the overall purposes of the land claims agreement. Back to ordinary meaning, real property taxes. Schools, water, yes, we saw that. All other kinds of expenditures that can be considered to be for the local good. And in this context, what is local? Local is the general taxation area and all of the communities within it. Now, both appellants in their submissions seem to suggest that the operations on the Marys River lands are somehow a standalone, that it just sort of dropped out of the sky, doesn't affect the surrounding areas, doesn't draw on any of the benefits of the surrounding areas, is absolutely self-sufficient, and with the exception of the royalty and rent payments to QIA, everything else belongs to BIMC, with the exception of what they choose to put out into the community. Well, common sense tells us, as does everyday activity in that area of the North, that this operation is not standalone. It affects communities around it. It draws on communities around it. It draws in the entire settlement area subject to the land claims agreement. There are specific boards set up to look at the impacts on the broader community. It's not restricted to the corners of the parcel of land upon which the operation is. Any commercial activity on Inuit-owned lands is meant to benefit all. And how can that be accomplished? Through the property tax base. When you've got infrastructure and valued at, you know, currently over $85 million, and it's not being taxed, then the broader community is not benefiting. I can't think that that was ever the intention under the land claims agreement. And for BIMC to suggest that it doesn't use nor benefit from local government services is frankly difficult to comprehend. Who's educating its workers? Who's keeping them safe? They mean to draw on the surrounding communities for their employment base. Who's schooling them? Who's funding that? Those local government services directly benefit BIMC. Infrastructure, housing, community services, all of that has to be expended by someone. And BIMC is there expecting to get the benefit. They want well-educated and healthy employees to run their operations and be involved in this project going forward. Who's going to do that? Local government services. It's not restricted to water and sewer that comes to one parcel of land. And on a go-forward basis, and we do accept that the decision made by the tribunal in this case is going to affect property going forward. So let's imagine that there was no lessee involved here. So BIMC is not here. We've got a parcel of land where that are Inuit-owned lands, and a commercial infrastructure is put onto that land, and it begins to generate profits in a commercial way, or it's a commercial operation, or at the very least, it doesn't. The activity there, or the improvement there, doesn't fall into one of the exceptions to the exceptions. Is that going to be subject to property tax? Yes. And it's the GN's view that that's what was always intended. That the encouragement for economic activity in the area is certainly there. And that is also a way to grow the tax base. It was never meant that it would simply be stagnant and any funds received from any economic activity flows to QIA and only QIA. It's meant to benefit the broader community. And how do you do that? You do that by the age-old property tax, indirect tax on wealth to distribute throughout the land base. It's difficult to contemplate that the agreement was not meant to do that. Of course, Inuit-owned lands are absolutely exempt from all taxes. However, once there are improvements then that's when they should be assessed and taxed for the benefit of all. And at the risk of oversimplifying it, to the GN, that's the answer to the threshold question. When are Inuit-owned lands accessible and taxable? When they contain improvements, except if they are the type of improvement listed. That's certain and not difficult to understand on a go-forward basis. And in our submission, exactly what was intended under the land claims agreement. It's never intended to draw on proximity, vicinity, or use of local services. So that concludes our submissions on the threshold issue. It's 2:00 Atlantic, so it's probably only I think we were taking the break at 2:30, so I don't know if you'd rather have Mr. Baxter start now or whether you'd like to take the break now. Partly up to you, Mr. Baxter, as well.
My preference would be to continue, but that would mean an interruption, Brian. So what would you prefer to do?
Yeah, I think this is a natural point for a break, Mr. Chair, but your preference. I'll do whatever the panel wishes.
Mm-hmm. And we're certainly at no risk of not having enough time in the hearing, so.
Okay. So to everyone's indulgence, then we will go ahead and take a break now. Then we'll come back 1 hour from now. So for me, it'll be 12 o'clock local time. And if everyone's okay with that, we'll go ahead and break.
Thank you, Mr. Chair.
Okay. Thank you.
It's coffee, it's delicious. And you know what else is great? These Keurig K-Cup pods are recyclable. And this K-Mini Plus brewer is made in part with recycled plastic. Now I get it, recycling. I thought it said cycling. I didn't need to wear any of this.
We built our icons of future. We electrified the Mustang, made the F-150 a hybrid, and reimagined the Bronco. This is the future we're building, and we're building it today.
I think we have everybody back. Okay, well, welcome back. And we're going to continue on with the Council for the Government of Nunavut. I think Jane had concluded a portion of the presentation, and we're going to pick up with Ryan Baxter to continue. I'd like to go ahead and continue, Ryan.
Great. Thank you very much, Mr. Chair. Can everyone hear me okay? I sometimes have issues with my audio, so if anyone is noticing anything, please don't hesitate to jump in and interrupt. I'm dealing with a monitor directly in front of me, a laptop to the left, and a phone to the right. So I'm never quite sure what is picking up my voice. So sometimes I do cut it in and out. If that happens, like I said, please don't hesitate to interrupt. I'd like to spend some time this afternoon speaking about valuation. So we are going to return back into the technical aspect of this matter. And having said that, I really welcome the panel members. If there are questions that you have during the course of my submissions, I'm more than happy to take them in the moment if you think that would be of better use of everyone's time. Or if you think you may be forgetting, I have a very short-term memory. So if you care to ask the questions live, I would certainly welcome that. And I say that because some of the information that I'm going to be presenting is quite technical in nature. So I'm just going to go ahead and share my screen now and hope that I can do this with some degree of success. All right, so as I mentioned, we're going to be talking about valuation this afternoon, specifically 3 areas assessed, and of course we would argue are subject to taxation. The first one is going to be the infamous tote road. Following that, we'll get into a discussion about some of the equipment that has been assessed.
My apologies to interrupt, but you should probably switch your screens. Right now, the presenter view is being shown, and whatever notes you'll have will actually show to everyone.
All right. Is there a manner in which you can help me?
If you go to display setting right there on the presenter view. No, up top.
Up here.
It says display setting. Top left.
Display settings, yes.
Yep. And you swap presenter view and slideshow. Yep.
That do the trick. Great. Thanks, Bruno. And then after we discuss the crushers, we'll talk about the land, the general land. So to start off with the tote road, these are just some of the highlights that I will be arguing this afternoon on the tote road. These are the high points. First and foremost, the tote road as we know it today in its current form was designed and intended for BIMC's use. I don't think that is controversial, and I don't think there's any dispute on that. We also know that the tote road has been substantially improved by BIMC, including bridges, structures, and improvements to the road itself. Why were those improvements made? Only one reason. Those improvements were made for the mine operators' use to haul the ore from the quarry, from the mine site to the port. I'll also spend some time talking about how PATA does not exempt the tote road that's on Inuit-owned land. We certainly acknowledge and recognize that PATA does exempt the tote road on Crown land, and we'll discuss that, but want to be very clear that PATA does not exempt the tote road on Inuit-owned land. Further, we recognize and acknowledge that the Nunavut Land Claims Agreement does create a public access easement. And we'll take a look at that. We'll pull it up. We'll look at the language of it. And we'll also look a little bit about the history and whether or not this public access easement existed prior to the Nunavut Land Claims Agreement coming into effect. And finally, on this item of assessment, in any event, the government of Nunavut is only assessing 50% of the improvements to the road that is on Inuit-owned land. There's a recognition, and although the factual basis for this recognition by no means is strong, there is a recognition that there's some use of the towed road by the public. Accordingly, the GN has assessed the road in the mine's favor by applying a very significant reduction to reflect that very limited public use. We will revisit that as well. I just wanted to set out those points on the front end. So let's go to PATA. That is where I would like to start here this afternoon. And clearly, PATA is where the liability for the assessment and taxation is. So subject to Section 4, all improvements are liable for assessment. So that's what we're looking for here. It is the improvements to the towed road that are being assessed. Again, at Section 7 of PATA, we see that an assessor shall. Shall is a very important legal word. Shall is mandatory. There is no option for the assessor, whether he or she decides to assess or not. The legislature has said that the assessor must assess all improvements that are liable to assessment in accordance with the regulations, separately from the land on which they are located. So if there are improvements and they are liable to assessment, they must be assessed, and the assessor has clear instruction in that regard. So here it is. I am benefiting from the use of my friends with QIA. This is the hearing, and I do think.
Ryan, I just
You're cutting out.
Yeah, sorry, you're cutting out on my end too, Ryan.
Feared that. Here, Mr. Chair.
I still have you cutting out a little bit, Ryan.
Yeah, okay, let me see if I can grab.
From where you are right now, it's clear.
Sorry?
Your last sentence was crystal clear.
Oh, hi. I may try some earphones.
Can you hear me any better with this?
I can hear you.
Okay. All right. Thanks for letting me know.
Sorry.
Yes.
Sorry, Ryan, the volume is very low. I'm having trouble hearing you. And I think my computer is up to full volume. Sorry.
No, that's quite all right. I anticipated that I'd have issues. Is it better when I get close to the laptop? Like, is this okay?
Yes, it is. Definitely better when you're close to the laptop, Ryan.
Okay.
Sounds great now. Thank you.
Good for you too, Miss Madden. Okay, so I think it is the laptop that's picking up my voice, so I'm just going to scoot right up as close as I can to it. So we have this map in front of us that is showing in red the towed road going from the mine, which is represented in that black gradient, and the red towed road that goes to the port, which is the blue gradient. I'll come back to this map a few times when I'm talking about different parts of the Tote Road, because as we know, the Tote Road crosses and is over both Crown land and Inuit-owned land. So we will revisit this slide a few times, but just to situate us, that's where we are at. So just to add some further flavor or further description of the purpose and the intent of the Tote Road in its current state today, this is from Jerry Town's affidavit at Exhibit W. This is not Jerry Town's document. These aren't his own words, but this is a document that's appended to his affidavit. And it's a 2019 inspection of the Milne Inlet Tote Road, in which in the very beginning, in the introduction, clearly states that the Tote Road was redesigned for heavy hauling in 2013. It's been upgraded in many locations since the 2014 inspection. It then goes on in a bit more detail to describe the Tote Road. There's an acknowledgement here that the Tote Road, in some manner, did exist prior to BIMC arriving in Baffinland. I think my friend Mr. Halpin made that comment earlier this morning. That is true. It's certainly not in the same condition as it was in the 1960s, though. And that's the point. It's the improvements to the road that the GN is assessing. I also want to make the comment that the Tote Road in its current form today, it roughly follows an access route that was established, but not exactly. So it is different. It is a different road today than it was in the 1960s, certainly. Now, going to Mr. Town's affidavit, specifically, he also offers some flavor and some characterization of the Tote Road from his viewpoint as the assessor. So he is saying that the Tote Road and bridges, what is their purpose? Again, it's designed and used for large or all trucks and used extensively as a core transportation route for mining purposes. He then provides some statistics that come directly from the Nunavut Impact Review with respect to the number of transits that are being made on a daily and a yearly basis. And those numbers are from 2017 and are taken from the Nunavut Impact Review Board report that is at Exhibit S of his affidavit. Now, my friend, Mr. Young made the point when she was getting into her presentation that the tribunal, thankfully, does not need to concern itself too much with the math. The math has largely been done. The parties know what they agree on and the parties know what they disagree on. So this is the items, the assets that are in disagreement, and they're broken down for all of the years that are currently in dispute. Returning now to PATA, in PATA at Section 4 of the Act, there is an exemption from both assessment and taxation. So Section 4 clearly states, it lists out a number of exceptions. What is exempt from taxation under the PATA regime? And at E, it clearly states any land that is vested in Her Majesty in right of Canada. That is described in subsection 2. So we have an indication right there at E that if it's Crown land, if the government still holds the land, if the title to the land is still with the government, still with the Crown, we know here at 4E, subject to what's in the following subsection, may be exempt. So let's go to that subsection, which appears directly below. So the land that they're referring to includes a road designed or intended to be used by the public, but not shown on a plan or survey registered under the Land Titles Act. So any roads on Crown land are exempt from taxation. That's what this section effectively is telling us. So from that, I think that part is clear. We can't be assessing any portion of the tote road that's on Crown land, because in very clear language, PATA tells us we can't. And as an aside, Crown land is never subject to taxation. It would just be the Crown taxing itself. So that piece is pretty straightforward. Anything that's on Crown land for the tote road is exempt from assessment and taxation by virtue of PATA. We recognize that, we acknowledge it. This portion here, returning to the map that is on none of the parcels, the colored parts are the parcels, and I will be returning to that. But that small portion that is not on the parcels in that white area, that is the Crown land. So that is the piece of the tote road that has been exempted, and GN has not assessed it. We've excluded that pursuant to PATA. However, what PATA does not do, it does not exempt the portion of the road that is on Inuit-owned land, which, reverting back, we can see is the very vast majority. Why doesn't it? Why doesn't it exempt road that's on the Inuit-owned land? It's because the words of the statute, and we've spent a lot of time in this hearing talking about how do you interpret a statute. The language here is very unambiguous. It's clear. We know who Her Majesty and Right of Canada is. It's the Crown. There's no mention here that the exemption applies to Inuit-owned land. If the legislature intended for that to be the case, it certainly could have amended the legislation to reflect that choice. It has not done so. The language states that it is Crown land to which the exemption applies. Our favorite case, if you remember one case from this whole process, it will probably be Rizzo Shoes. I think all of the parties have made mention of the Supreme Court of Canada case, which is the guiding case when it comes to the interpretation of an act or a statute. And what I think is helpful from Rizzo Shoes here is that the words are to be read in their entire context, in their grammatical and ordinary sense. So there's no ambiguity when it comes to land vested in Her Majesty, the Right of Canada. That is the Crown. Now, my friend yesterday made an argument that I think we have to unpack a little bit more here. And this is returning to the Nunavut Land Claims Agreement, and at section 21.7.1, where it talks about existing interests. And if there was an interest that existed prior to the Crown giving land to the DIO, then that third-party interest should continue, even though it belonged to the Crown, if it exists immediately prior to the vesting of the land. So if there was a public easement on the land prior to it being given to the DIO, then that interest should continue. It's effectively what this section is saying. In order for this section to apply, however, there are some very critical prerequisites that simply are not engaged here in this case. First, it says where Inuit-owned lands are subject to a third-party interest. So what is a third-party interest? I think that's our starting point, what we need to consider. Thankfully, that has been defined for us. We don't need to guess. It is in the land claims agreement at 21.1.1, where it says a third-party interest means, for the purpose of that section that we just visited, a right granted under the Territorial Lands Act or the Public Land Grants Act that is enforceable against the Crown. You will not find in either of these pieces of legislation a right-of-way, a easement, public access with respect to the Tote Road. It's not there. There's no third-party interest that's being engaged in this case. There's no third-party interest that was in existence immediately before the vesting of the Inuit-owned lands. So for that reason, the government's position is that this section is not engaged at all because there's no third-party interest at play. Even if there was, and we're saying there's not, because when we look at these two acts, the Territorial Lands Act and the Public Lands Grants Act, we do not see any rights with respect to the Tote Road. Even if there was, it would have to be in existence immediately before the vesting of the Inuit-owned lands. I'll suggest to you that there's nothing in the record before this tribunal that suggests or establishes that there was a public easement that existed immediately before the vesting of the Inuit-owned land. Rather, as we'll go to in a moment, the public easement with respect to the Tote Road, it actually came into existence when the land was vested. It didn't exist prior, but it came into existence upon the vesting of the Inuit-owned land. And again, for that reason, we say Article 21.7.1 has no application in this case. So let's take a look at the easement. And the easement is in the Nunavut Land Claims Agreement at 21.4.1. And it states, there shall be a public right of access. And then it's pointing us, it's not coming out and telling us what the public right of access is. It's saying you need to go look for it later on in the document. And that's at Schedule 21.2 on the Inuit-owned lands described in that schedule. So we know that there is a public right of access. So let's go take a look at that. Here it is. Here's the language of the public access easement in the Nunavut Land Claims Agreement with respect to the Tote Road. So it's at Schedule 21-2, and we have the location. So we know we're in the same area, specific reference to the Milne Inlet Tote Road, and the easement is described as follows. There is a public right of access for the purpose of transportation. So that's important. The public right of access has been prescribed in the Land Claims Agreement. It is for a very prescribed purpose. It's not for any purpose. It's for the purpose of transportation. That is what the parties agreed to when it came to the wording of this easement description that is applicable. And we will revisit that in a moment. The reason why we will revisit that in a moment is because the evidence and the record before this tribunal is extremely scant when it comes to public use of the Tote Road for transportation. So we will revisit that. But let's just talk a little bit about what the GN is assessing and taxing when it comes to the tote road. So is it the tote road on Crown land prior to the improvements? No, we know that. We know it's exempt by PATA. Is it the tote road on Crown lands with improvements? No, we can never tax Crown land, regardless if there's improvements or not. Is it the tote road that's on Inuit-owned land without improvements? It's not even that. As I said, what is being assessed and taxed is the improvements to the road. So if there's no improvements, it's not being assessed or taxed. So what about the improvements that are on the tote road that are on Inuit-owned land? Certainly that has to be taxable. Not even that. We're not even seeking 100% of the improvements to the road on Inuit-owned land. Instead, what the taxing authority has done is assessed the improvements to the tote road on the Inuit-owned land at 50%. And if you look at Mr. Town's affidavit at paragraph 81, he sets out the reason for his decision to assess it at 50%. And the reason for that is the public use acknowledgement, that we recognize that there is, although it's scant and extremely limited, there's some public use, and they've applied an extremely generous reduction to reflect that use of 50% of the improvements that are being assessed. So again, what is it that's being assessed? It's the bridges and it's the road upgrades. Whatever BIMC has done to the tote road in order for it to support these heavy ore haulers going back and forth across the road every day. That's what's being assessed here. It's those improvements, those bridges and structures and road upgrades. Now, I've spent some time arguing that PATA is not applicable in the circumstances. And my friends made the argument that it is applicable. So I want to kind of engage in an analysis in the event that I am wrong, in the event that the very clear and express words of PATA are interpreted differently by the tribunal. Let's see what section 4 of PATA does apply to the Inuit-owned land. So if we're saying, yes, land vested in Her Majesty and right of Canada, that means somehow Inuit-owned lands. Well, let's take a look at that. So it would bring us to subsection 2 sub B. The exemption applies to a road that is designed or intended for or used by the public, but is not shown on the plan of survey registered under the Land Titles Act. So that's what needs to be satisfied. It needs to be designed or intended for or used by the public if section 4 applies. So let's unpack that a little bit more. I think we spent some time, enough time already, that we know that the tote road improvements, the tote road in its current form today, was not designed or intended for the public. It was designed and intended for a commercial purpose. There's nothing wrong with that. That just means it's liable for taxation. And this is the report that I alluded to earlier, which gave us a little bit about the background of the tote road and some of its history. So this was the 2019 inspection of the Mill Inlet Tote Road, which was presented to Baffin Land in 2019. So this is where we see those descriptions, the purpose of the road when it was redesigned for heavy hauling in 2013 and subsequently it's been upgraded. We know the purpose for that. That's not in dispute. So it's not for a public purpose. So we know that we can't rely on the first two categories or buckets here. We know that the road was not designed or intended for the public. But what about the last one? The word or is there, right? And so that's an important word. It's not and. It can be any one of these things. It could be designed for the public, intended for the public, or used by the public. So we've crossed out the first two, I would say. What about if it's used by the public? So let's take a little time looking at that. So when we look at the easement that's at play here, the words are very clear, and the word and the right is prescribed. It's the public right of access for the purpose of transportation. It's not a public right of access for any purpose. That's not what the easement says. The easement says that it's a public right of access for the purpose of transportation. There is no evidence before the tribunal that the tote road is used by the public for the purpose of transportation. There's certainly evidence before the tribunal and in the record, although I would respectfully submit that it's very scant, that it's used by the public. That's there. We know Mr. Anderson in his affidavit says that it's used in the summer months by members of the public. But what is it used for? What is the purpose that it's being used for? It's being used for the purpose of hunting, not for transportation, which is what the explicit words of the easement say. And as well, another example that he presents is that it was used for a dog sled race, a sport. Again, not transportation, not meeting within the very prescribed language of the easement. So I would suggest that there's no evidence before the tribunal that the public does use this road, which is in a very remote, largely inaccessible area of Baffin Island for the purpose of transportation. That's not the use that is being made by the public. It's being used for hunting and dog sled races for sport, but not for transportation. What I wanted to go into now is just to paint a picture of BIMC's control of the tote road. We've heard argument that there is a public right-of-way, there is an easement, that the public can use the tote road, and that's enough, that's sufficient. That makes it public and not subject to assessment or taxation. For the reasons that follow here very shortly, the government of Nunavut does not agree with that submission. In our view, based on the record, Baffin Land exerts a significant degree of control over who uses the tote road, how the tote road is used, and pursuant to what conditions the tote road may be used. And the case law that I'll talk about later on will show that such significant control of a road effectively renders it no longer public. When you have such conditions and restrictions and control, it's no longer a public land, despite there being an easement. So we'll take a look at what I mean by Baffin Land's control of the tote road. So the first document that I would like to look at is a 2019 socioeconomic monitoring report for the Mary River project, and that's in Mr. Town's affidavit at Exhibit X, and this was prepared for Baffin Land. So when we look at the report itself, we see a statement here that mine site related mitigation developed by Baffin Land includes, I've underlined in red, Baffin Land's policy prohibiting the public from unescorted travel on the tote road. So there's a prohibition. Baffinland has a policy that's prohibiting the public from unescorted travel on the tote road. Baffinland, it continues, will instead transport land users and their equipment on the tote road in order to prevent land user tote road traffic interactions. Moving on to a series of documents that are authored by Baffinland itself. Baffinland has a roads management plan that applies to the tote road. So this here is a document, has a series of approvals by individuals within Baffinland, and this is available at Mr. Town's affidavit at Exhibit T. At section 7.3 of BIMC's road management plan, we have a description here that the health and safety manager, in concert with the environmental manager, maintains a registry of sightings, locations, and frequencies of non-project related individuals in a human use log. So there's a degree of monitoring and tracking and reporting of individuals who do go on to the tote road. And any of those sightings must be reported to security. So sightings of non-project personnel, so that would be the public, those have to be reported to security, and they have to be reported and recorded in human use logs. It further goes on and says all visitors and non-project individuals traveling near the tote road will adhere to the hunter and visitor site access procedure. So again, we know that there's monitoring, there's reporting and recording of public using the tote road. There is also a Baffinland document entitled the Tote Road Travel Procedure. So we'll take a look at that. That document, BIMC's document here, says that all persons traveling the tote road must check in with the security office or dispatch at both Mary River and Milne Inlet. Again, we see that word must. Must is mandatory. There's no option here. It must be done. All personnel must be accounted for when traveling the tote road. So there's a significant degree of monitoring here. There is a requirement to check in with Baffinland if you are going to be using the tote road, and there's an accounting of anyone who is using the tote road as well. Going to Baffinland's hunter and visitor site access procedure. It says that everyone, and they've italicized, they put some emphasis on the word everyone. Everyone is required to comply with Baffinland's safety procedures and camp rules. Now, I do want to say, and this is only being fair to my friends, that the document itself does state that Baffinland recognizes that the beneficiaries have a right of access under the Nunavut Land Claims Agreement for the purpose of harvesting. So they acknowledge that there is that right under the Land Claims Agreement, but despite that acknowledgement, they're attaching significant conditions and restrictions to anyone's use of the tote road. Continuing in that document, again, we see that site security will assist the environmental department by documenting the arrival and departure of site hunters and visitors in the human use log. So similar language, but repeated here again in another place in their policies, that there has to be a documenting of departures and arrivals and departures in a human use log. At 5.1.3, there's a section that says travel along the tote road is prohibited. So unescorted travel along the tote road is prohibited at all times. I think those words speak for themselves. Continuing in the hunter and visitor site access, again, there's descriptions here of a travel of hunters and visitors, seasonal travel, starting with summer travel, the obligation that all hunters and visitors must notify the security department if they intend to travel between Millport and Mary River, continuing to say that they will provide arrangements for a safe method of travel, which will be determined based on resources available and the size of the party. So lots of conditions and stipulations here. It's not free movement. It's not enter the tote road and use it as you wish, how you wish, when you wish. There's a number of conditions that must be adhered to. Similarly, in the winter season as well, where again, you know, it's to my mind, when I'm reading this, it appears to suggest that crossing the tote road is okay, but travel along the tote road, again, is prohibited at all times. So you can cross it, but you cannot travel along it. That is prohibited at all times. So very limited use, I suggest that this policy is prescribing. So knowing that, having that context of the significant degree of control that the GN states that the IMC exercises over the tote road, what does that mean? I said earlier that the case law will show us that when such a significant degree of control is exercised over a public place, it means it's no longer public. The first case that I want to start off with, and these cases all involve some sort of offense involving a motor vehicle. So the first one is a New Brunswick case from 1997, Ballard, R and Ballard. So a construction worker was operating a bulldozer. There was a project on Provincial Highway in New Brunswick, and the worker who was operating this machinery was widening a highway that was under construction. And while he was doing this, only one lane of traffic was permitted. And I think we're all accustomed to that, particularly in the summer, when improvements are being made to public highways. Oftentimes traffic is closed to one lane and there are flagged persons at either end of that lane directing traffic and directing and controlling the traffic. The area that the construction worker was operating the bulldozer, it wasn't separated by any barrier. There was nothing to prohibit a public motorist from driving on that area that he was working on. So the Crown said that the widened area of the highway was part of the highway system, and it was owned by the province, and accordingly, it was a public place. Why this is all important is that the construction worker was committing an offense while he was operating the bulldozer. So I believe he was intoxicated. So pursuant to the legislation, you cannot operate a motor vehicle under any influence or intoxication. So the question was he traveling along a highway? And if so, that is an offense and you will be prosecuted. Or was it a public place? And if it was, then there is no offense and there is no prosecution. So the case turned on whether the part of the road the bulldoze operator was traveling along was public or not. That's what the case turned on. The Crown said Absolutely, yes, it is. It's part of the highway system. It's owned by the province. It's a public place. So he was traveling and it was an offense. Where the defendant said, well, no, this portion of land was under construction and it was not open to the public, and therefore it was not a public place because there was that degree of control with the flag persons on either end of the lane that was open. Ultimately, the court said it was not public. So Ballard was found not guilty. And the court said that when we're looking at the word public place, it is a term, a word that fluctuates, and we really need to look at the context. The contractor clearly had control over the area that was being worked on at that time. They designated a portion of the area to which the public had access. They had placed flag persons at either end of the lane to keep traffic within the confines of that lane. So at the time that the offense was committed, the area being worked on was controlled by the contractor. Controlled by the contractor, no members of the public were present. Therefore, the court said it was no longer a public place, despite it being designated and adjacent to a highway. So that degree of control from this case, I think, is very helpful in applying BIMC's degree of control to the tote road. In another New Brunswick case, I don't know what they're all doing in New Brunswick, but in another New Brunswick case, this is R. and Prince, the court set out that the test to be applied in determining whether driving has occurred in a public place is do the ordinary general members of the place have sufficient degree of access. So do they have sufficient degree of access to make it a public place? In that case, that's what they said the question was in determining whether a road was a public place. Moving west a bit, this was a Court of Appeal case out of Alberta. So R. and Fox, where a defendant was driving his car, entered upon a gravel road, which was in the confines of the Snowden Band Indian Reserve. When he was driving down the road on the reserve, he collided with another vehicle, but failed to report. So he was charged with an offense for failing to report an accident. And the main issue here was the road that the defendant was driving along. Was it a highway pursuant to the Motor Vehicle Act? That's the question that the court had to resolve. So this road that was on the band's land, it was constructed and maintained by the band, and it was constructed and maintained with funds provided by the band council. It was built. What is the purpose here? It was built for the use of members of the band to allow them to access to and from Highway 1A. As a measure of control, the band maintained a rule that anyone wishing to enter the reserve for whatever purpose must, before doing so, apply for and obtain a permit for the band council. So there was a requirement here that anyone who wanted to use the land obviously would have to go through some steps beforehand. That's quite similar and analogous, I think, to what BIMC's policies require for hunters and visitors and members of the public. They have to check in, they have to be escorted. There are a number of prohibitions. So I think it is analogous to what occurred in R and Fox, and the measures of control, I think, are analogous. So in that case, the court said it found that that road was not public. It did not fall within the meaning of the word road pursuant to the applicable regulations, which was under the Indian Act. So no offense was found to have committed despite the collision and failing to report because it wasn't a public place. Why wasn't it a public place? It wasn't a public place due to the significant degree of control and restrictions that were in place over that road. So again, just to step back and discuss the tote road very broadly, we know in its current form today, it was designed and intended for BIMC's use. Nothing wrong with that. We know that it's been substantially improved for BIMC, including the bridges and the structures, again, for their use. We've taken a look at PATA. We suggest that PATA does not exempt the tote road on the Inuit-owned land. We do acknowledge that it does exempt it on Crown land, however, but Crown land and Inuit-owned land are extremely, extremely distinct. We know that there is a public access easement. However, there's no evidence before the tribunal that that existed prior to the vesting of the land. We also took a look at the language of the public easement and recall that it's for the purpose of transportation. It's prescribed for that purpose. It doesn't provide for anything else. And we also took a look at how significantly the policies in BIMC control and restrict. And we know, looking at Michael Anderson's affidavit, the transcript of his cross-examination, although there's acknowledgements of these policies, I believe he makes some comments that they aren't necessarily followed or adhered to. And I don't think that's a material distinguishment here. These are public documents available for anyone to read and see. They are policies that have been, the company invested time in creating them and publishing them and reviewing them. And the words say what the words say. And finally, the only other point that I want to make here is recall that the GN is not assessing and taxing the tote road in its entirety. It's limiting its assessment to those improvements that have been made to the tote road for the haulers. And in any event, it's only assessing it at a rate of 50% in acknowledgement of the public use, the very limited public use that is made of the land. So a very reasonable approach, I would submit, that the GN is taking to this assessment. It's really tailored what is being assessed in the circumstances, recognizing those variables. So that's really all I wanted to state on the tote road. And now I'd like to move on to the other area of contention when it comes to valuation, and that is equipment. So with respect to equipment, I'll be talking about how, from the GN's perspective, the equipment that's in disagreement, one, it is slightly fixed to the land, and or it's an integral part of activity. And both of those things are very important, and we'll talk about why those things are very important. But because either one or both of these factors apply, they are subject to assessment and taxation. So our argument as to why the equipment is assessable is based on 1 and 2, and only one or the other need apply in the circumstances in order for them to be subject to assessment and taxation. So again, going back to the statutory authority, what is liable for assessment? We know that land, improvements, mobile units, pipelines, works and transmission lines, we're only focused at B here. We take the position that the equipment at issue are improvements, and we'll take a look at why we say that. At first glance or first consideration, it may not seem intuitive. How can a crusher be considered an improvement? But we're going to unpack that definition. We're going to explore what that definition is. I'm just making the point here that I don't want you to be misled into thinking that we're talking about liability for mobile units or not. We're talking about here is a list of the matters that are in disagreement between the parties for each of the taxation years. Again, you don't have to concern yourself too much with the math or how these numbers were formed, but those are the numbers and they do appear in Mr. Town's affidavit as well. So these are the actual things that we're saying are accessible. So you'll see very many references to crushers, crusher installs, installations. So that is the list of items. So first, let's just go back to accessible property. So what is accessible? We know that what is accessible includes land, improvement, mobile units, pipelines, or works. We're only dealing with improvements here, so let's jump right into it and get to the definition of improvement and why the GN says these crushers are improvements. So here is the definition at section 2 of PATA. The first thing that I want to point out to, although we're listing A through D, we use the word or here. Right at the end of subsection 3, at the very end of the sentence, it says or. So what that means is you only have to fit into one of them, not all of them. This isn't a checklist. We don't have to go through and meet each of those. We only need to meet one of them in order for the definition to apply to the crushers and other equipment. So that use or is very intentional in legislative drafting. The opposite of or is and. If the word and was used, we would have to be meeting all of these 4 conditions, but we don't in this case. So let's start at B. B says that an improvement is everything fixed to the land, even slightly. So there just has to be some fixation to the land, but it only needs to be slight. So that's a very low threshold that the legislature has stated for that definition of improvement. At C, we see that an improvement is any machinery, equipment, appliance, or other thing forming an integral part of an activity on or use of land other than a residential use or activity, whether or not that thing is mobile. So we know from 2C that any machinery or equipment that's integral is an improvement. It doesn't matter if it's mobile or not. It can have wheels. It can be moved around the site. But if it's integral, then it's an improvement. It doesn't matter whether or not it's mobile. And at D, an improvement is anything forming an integral part of the things referred to in paragraphs A to 3, unless there's evidence showing that it was intended that the thing was to remain separate from the. So I will spend some time in B and C here to show from the GN's position that the crushers and related equipment are improvements and thus subject to assessment and taxation. So Mr. Towns says, in his opinion, as the assessor on behalf of the GN, that the crushers, conveyance, and related equipment are improvements because they are integral to the mining and operations. He goes on to say that all mines in Nunavut have crushers, conveyors, and related equipment as they are required for respective mine operations. Not only do all mines in Nunavut have these types of equipment, but all mines in Nunavut have this type of equipment assessed. Now, we did hear some comments this morning from my friend, Mr. Halpin, regarding whether or not the crushers are integral to the operation or not. And I just wanted to spend a little time focusing on that. Integral means it's necessary. There's a necessity to the operation. So BIMC has used, taken the time to expend human and financial capital to relocate some pretty sizable pieces of machinery and equipment to Baffinland at what I can only imagine would be at a significant cost. You know, why would that be done if it was not needed for the operation? Mr. Halpin also spent some time saying that, you know, if a railroad, and we're all aware that there are discussions and there are plans and talks about a railroad being constructed, which would preclude, as I understand it, the use of the tote road. And you can look at the record, but this morning he did say that the railroad will remove the need to crush the ore. Well, what that says to me is that if you don't have the railroad, there is a need to crush the ore, because when the railroad comes in, that need to crush the ore is no longer present. But currently, today, the railroad doesn't exist. There is a need, and it is happening. The crushers, the conveyors, they are being used as part of the process. If the railroad is constructed and the crushers are removed, well, certainly they would no longer be subject to assessment or taxation. But that's not the reality today. The reality today is that the crushers, conveyors, and related equipment are being used. They are part of the operation. This is an aerial view of the mine site. You can see where there is a crusher pad in about the middle of the photo. So substantial thing we're talking about here. The crusher pad is what is used to place the crusher on top of. So there's a design and there's construction that takes place in order to enable the use of the crusher. So a lot of work seems to go into being able to use these crushers. Here is an aerial view of the crusher facility. And this is a reference from a Baffinland document, just showing, you know, that there have been drawings, there's been design specifications for the mine site crusher pad expansion. So clearly these aren't insignificant things that are being done to the land when there are design specifications and drawings for its expansion. Just wanted to make a note, yesterday during my friend Ms. de Jong's presentation, there was reference to the crushers being portable. And, you know, in my position, nothing turns on whether they're portable or not, pursuant to the definition at subsection C. But what is shown here in this photo isn't a crusher, it's a conveyor. It's used as part of the process, but I just want to be clear from the GN's perspective, that is a conveyor, not a crusher. But in any event, if the crushers are mobile or not, doesn't matter pursuant to the definition of improvement at section 2C. So not only do we need to look at what is defined as an improvement, but we also need to look at the exemptions. So the Act says these are improvements, and this is what you have to back out. These are things that are not improvements. Pipelines, works, and property include machine, equipment, appliance, or other thing that is portable.
Ryan, I have you cutting out again. Can't hear you. Not sure why. Can everybody else hear?
Is this any better?
Yeah, that's better.
Okay, I'm sorry about that. I think it's making a change in the background between which speaker is picking up, and I have no idea why. Where did I drop off, Mr. Chair? Oh, sorry, you're on mute there.
You might want to back up a minute or so.
Sure.
Yeah.
So all I was saying here at this point is that not only do we need to look at what is defined as an improvement, but we also need to look at what the exceptions are to those definitions. So that's what I was getting into here. And that includes land, mobile units, pipelines, works and transmission lines, none of which are applicable, but B is interesting. So B includes personal property, including vehicles or machinery, equipment, appliance, or other thing that is portable. So that would tend to suggest that maybe that does capture the crushers or the conveyors if they can be moved around the land. Except there is a further exception which says, except as provided under paragraph 1C or 1D. So we need to go back to paragraph sub 1, B, C, and D. And that's where it returns us to the definition. So what is being excluded that is portable? Any machinery, equipment, appliance that is integral. So again, the exception is not applicable to C and D. If you have personal property, if you have a vehicle and it is portable, it can be exempt except if it's integral. And we make the argument that it is integral. If it wasn't integral, it wouldn't be there. So in our submission, the exceptions do not apply. At first glance, they may seem that they apply because look, it's talking about machinery that's portable, but then we have to go the extra step and there's the further exception that it doesn't apply to the machinery or equipment if it's integral. And again, whether or not that thing is mobile or not does not matter. The evidence for an improvement, it's anything that shows the extent or amount to which the thing is affixed and can clearly seen by physical inspection or by reference to design plans or other documents, which we saw reference to earlier. So overall, we say that the equipment at issue does satisfy the definition of improvement in PATA, either in the case that it's slightly affixed to the land or it's integral to part of the activity. Again, it need only satisfy one of those criteria in order to satisfy the definition. And we further say that there are no exemptions that apply in the circumstances, thus making the equipment subject to assessment and valuation. So the last piece that I would like to address, Mr. Chair, is land. So this is the land that is outside the impact area and exploration zone. So the points that I'd like to discuss with respect to land is that parcels are accessible pursuant to PATA. In this case, they've been assessed as one parcel, and we'll take a look at why that is. We will show that the land has been fully demised. I know we've talked about, the word demised previously, and what that meaning is, so we'll take a closer look at that. And whether the land was demised to BIMC pursuant to the lease is not relevant here because it's not on the basis of the lease that the GN is assessing that land, but it's pursuant to the fee simple titles. So those are the areas that I'd like to explore with respect to the land. So again, going back, always starting with PATA and the liability at section 5A, liability land. Pretty clear. Continuing from that, the assessment of land at section 6, an assessor shall, mandatory language, an assessor shall assess every parcel that is liable to assessment in accordance with the regulations separately from improvements, mobile units, pipelines, or transmission lines. So what is a parcel? A parcel is defined in PATA in the definition section. So parcel means if land has been subdivided and the subdivision registered under the Land Titles Act, it's referring to each lot, block, or tract of land described in title or described in a certificate of title by reference to a plan filed or registered in the Land Titles Office. So this definition is not very critical, but it's further defined, and where it's further defined is critical. So here there are 4 parcels that are at issue, and these are them. And here they are, again, using my friend's map. These are the 3 parcels that are subject to taxation. So we know we have 3 parcels. So the question is, are these being assessed individually, or are they being assessed as one parcel? So the assessment authority has assessed it as one parcel. The reason for that is the tote road, which I argued earlier is an improvement. The tote road, as you will see, connects all of the parcels. Starts in PI 17, if we're starting at the bottom, goes on to PI 16 and up to PI 19. So the tote road, which is an improvement, connects all 3 parcels. That's important. Why is that important? Because the definition of parcel means if an improvement that is affixed to the land would be conveyed by a sale of the land and the improvement is located on 2 or more blocks or tracts described in paragraph B, all those lots, blocks, or tracts. So the improvement is located on 2 or more lots. The improvement, being the tote road, is located on 3 parcels in this case. So it has been assessed pursuant to the definition of parcel as 1 lot. And that's in accordance with the statutory definition of parcel in PATA. The assessor followed the definition and assessed the land as 1 lot. 1 parcel, excuse me. So here we see the parcels individually, and then what the assessor has used as the total subject property, which is the entirety of the 3 parcels. And it's then broken down into parts. So we're taking the land as 1 piece, as 1 parcel, and then it is being broken down into part 1, part 2, and part 3. Here is Mr. Towns explaining in his affidavit why the land is being assessed as 1 parcel. He says, since the same improvement is located on each parcel, the lots should be treated as 1 parcel. Again, the improvement being the tote road. The tote road is located on the subject property, is an improvement, and is located on all 3. So that's the rationale and the reasoning behind why the land is being assessed as 1 parcel. So although it's being assessed as 1 parcel, it is broken down into 3 different parts. Part 1, part 2, and part 3. So part 1 is the most developed portion of the lands, and that's about 10% of the total most developed areas of 4,000 hectares. Part 2, all those portions that are not located within part 1 or part 3 And then part 3 is the general areas. The general areas, as they're described in the lease with QIA, and BIMC makes an argument that those general areas that are outside of part 1 and part 2 should have a 0 development quotient. We'll show that assigning a 0 to the general areas is not permissible. So assigning 0 to the lands that have not been developed, that's not an option that the assessor has pursuant to the legislation. Despite it being a general area, despite there not being any improvements on it, it cannot be assigned a 0 value pursuant to the legislation. And although I was going to get to it in a moment, I suppose that I'll just speak to it now. So this is in the regulations of PATA, where it does assign the different quotients of a parcel or part. So the region that we're in Baffinland, is in Tiktaalik, which is the last region. And when we look at raw land, which is the land that has no development, has no roads, it has no improvements, it has no crusher sites, it's the general area outside of the impact and exploration sites. 7 must be assigned. So the number of 7 must be assigned. It's not an option that the assessor has. So when we look in the detailed calculations that the assessor has gone through in assigning the value, this number 7 becomes very important and tells us that we cannot assign a 0 value. So I did want to talk briefly about demised, because I know that has come up, and it is within the Nunavut Land Claims Agreement, where it says, notwithstanding an improvement has been constructed and an area of land for that improvement has not been demised, the assessor may assign an area no greater than 4 times the total ground area of the improvements. And BIMC says that land outside of the impact and exploration areas, that general land has not been demised. And they say it hasn't been demised because there's no right to quiet enjoyment. What needs to be clarified here is, what are we talking about when we're discussing demise, and what is the assessor looking at? The assessor is not looking at what has been demised pursuant to the lease. That's not what the assessor is looking at. The assessor is looking at the land in fee simple. What has been demised to the Inuit? What has the Crown, the federal government, conveyed to the Inuit? All of the rights, all of the bundle of rights has been fully conveyed from the Crown to the Inuit. It has been fully demised, conveyed. All the rights are with the Inuit. If we look at it in the context of the lease, certainly there can be some argument that certain portions of the general areas have not been then demised by the Inuit to BIMC, but that's not the basis for the assessment. The basis for the assessment is what has been demised to the Inuit, and this land unquestionably has been fully demised. So it's not the context in which the lease that this is applicable. And we see that that is where BIMC it's doing its analysis. It's looking at this term in the context of a leasehold, and where lands are demised as part of a lease, the lessee is entitled to exclusive possession of the demised premises from the lessor. Well, I don't argue with that principle of law. But that's not the basis for which the GN is assessing that land. It's assessing that land in fee simple as land that is owned and belongs to the Inuit, not what has been demised to BIMC in the context of the lease. And here is just an article from the Nunavut Land Claims Agreement reflecting that complete and full demise from the Crown to the Inuit. So the GN is not valuing the lease here. They are valuing the fee simple titles, which is all of the land. And as we know, fee simple is the highest form of property ownership. The Inuit have full and irrevocable ownership of the land, and that's the basis on which we say the land has been demised. Already spoke to that slide with respect to being unable to assign 0 to raw land, as has been suggested by the IMC. The regulations are clear that 7, the sum of 7, the value of 7 must be assigned in the calculations. And those calculations are all set out in Mr. Tam's affidavit. So on that, the GN's position is that the parcels are accessible. They're accessible as one parcel. They're accessible as one parcel because there is an improvement that attaches all of them, namely the tote road. The land has been fully demised. Whether the land is demised to BIMC pursuant to the lease is not relevant. It's not relevant because the GN is assessing fee simple titles. So it's on that basis that the GN has assessed, pursuant to PATA, the general areas outside of the impact and exploration areas. And that brings me to the end of the 3 areas of valuation that are in dispute between the parties on valuation.
Thank you, Ryan. Does this conclude your entire party's presentation?
It's subject to anything Miss O'Neill may want to make. I'm not sure if she has any concluding remarks or not.
I do not.
Okay, what I would like to do is to take a 15-minute break, and then we can come back with council and panel members' questions. So
Thank you.
we could meet back at 20 to the hour.
Thank you.
Thank you.
Crunchitize me, Captain.
你看，在这个页面上，他是谁呀？太阳。哦，太阳，这。
Yeah, well, welcome back, everybody. I want to thank Jane and Ryan for a very good presentation. It was very well done. And at this point in time, what I'd like to do is open it up to questions from first the tribunal's counsel and then panel members themselves. So it's open to you, Kirk. Please proceed.
Thank you, Mr. Chair. Council, I'd like to begin by asking the Government of Nunavut a question similar to the one asked earlier, and it relates to the principles of interpretation here. So I heard the Government of Nunavut state, I believe, that all parties were agreed on the principles. So I wanted to ask you if this expression of it is the one that succinctly summarizes what the panel has to do, or what the parties are asking the panel to do in terms of the principles of interpretation. And that is, interpret the treaty in light of the context in the record in order to identify the parties' common intention.
Well, I can't speak for the other parties, and sure, that does articulate it. I'm not sure there's anything different in the way you articulated it just now than the way it's set out in Rizzo's shoes that we all rely on. Because the goal is always to find the intention by looking at the ordinary meaning of the words and all that sort of thing in the context in which they were written. So I don't know if that changes just the way you articulated it, changes it in any way.
All right, thank you for your answer. Can I ask you to comment upon how the definition of third-party interest in Article 21.1.1 of the Nunavut Inuit Land Claims Agreement may affect your submissions, or if it does, respecting the toad road?
I'll leave that to Mr. Baxter.
Yes, so Mr. Chair, you're inquiring about the definition of third-party interest?
Yes, the Secretary can pull it up if you wish. I believe it's 21.1.1.
Yeah, that would be helpful.
Mr. Secretary, would you mind pulling that up and displaying it for us, please? Mr. Baxter, the Secretary experienced some technical glitches this morning, so
okay, I may be able to pull it up.
If you'll be patient with us, we'll get there soon.
No, I may be able to pull it up.
There it is. You should be able to see it. Sir.
Could you enlarge that, please?
Okay, Mr. Chair, what was the question with respect to the definition?
Does this have any influence on your submissions regarding the tow road?
It does, yes. It does in the sense that it's engaged by 21.1.7. If we could scroll down, Mr. Secretary, to that article of the agreement. (21.7.1). So this is where that definition is engaged. So the article states where Inuit-owned lands are subject to a third-party interest other than an interest in minerals, or a third-party interest in respect of specified substances in existence immediately before the vesting of the Inuit-owned lands in the DIO, the third-party interest shall continue in accordance with the terms and conditions, but the DIO shall assume the rights and obligations of the Crown in relation to any such interest. So what are those interests that get conveyed from the Crown to the DIO if they existed prior to the vesting of title to the DIO? Well, we look at what third-party interest means as defined. And as defined, it means any rights that are granted under either two of the acts, the Territorial Land Act or the Public Lands Grants Act, that is enforceable as against the Crown. And my understanding is that there is no right granted under the Territorial Lands Act or the Public Lands Grant Act with respect to the Tote Road.
Oh, you're on mute, Mr. Lambert.
Thank you. Thank you, Mr. Baxter. While this is up, I would like to ask you for your perspective on who the third party is in this instance. If there is a third party interest, third party is defined as like any person in 1.1.11, I think, in the general definitions section. So who would it be?
So the third party interest, the grant that we're talking about in this context is the easement, which grants a right to the public to the land. To use
So would the third party be the public?
In this context, I think it would.
All right, thank you. And in one of your earlier slides, in talking about the Tote Road, you had a slide that discussed that it was an easement for transportation.
Right, so that is in the Nunavut Land Claims Agreement.
All right, which article?
So it's in a schedule. It's in Schedule 21-2.
Mr. Secretary, could you slide down? It should be just a few pages further down, I believe. All right, sir. Are you able to see that on your screen?
Yes.
All right. And this gives the easement a description.
Correct.
And it is said that the public right of access is for the purpose of transportation.
Yes.
Can I understand again what interpretation you would put on the phrase "for the purpose of transportation"? Please, I'm not sure that I fully followed what you're saying in that part of your presentation, sir.
Certainly, thank you. So we certainly acknowledge that pursuant to the Land Claims Agreement, there is a public right of access with respect to the Tote Road. Our position is that it is a very prescribed public right of access. The easement does not say public right of access, full stop. The description of the easement continues and prescribes it for the purpose of transportation. So we acknowledge that there is a public right of access for the Tote Road. What is that public right of access for? Well, the words speak for themselves. It's for the purpose of transportation. We submit that there's very little evidence in the record that the Tote Road is being used by the public for the purpose of transportation.
And maybe I need to ask you a more specific question,
Certainly.
and that is whether the public includes Inuit.
Yes.
All right, and if Inuit use the road for dog sledding, why do you say that is not transportation?
The dog sledding that we have in the evidence is with respect to a race. It is not with respect to moving people from one location to the other. It is a sport.
All right, so I think I have your submission on that point. Thank you. I would like to ask you about the question about demise.
Yes.
Now, do I understand you to say that the government of Nunavut's position is that the whole of the lands within the leasehold area shown on that map, which we've seen before, QIA 1330, has been demised?
Yes.
All right. And do I understand you to say that the demise is not the lease of these lands between BIMC and QIA, but the transfer of these lands from Her Majesty the Queen and Right of Canada to the status of Inuit-owned lands in fee simple?
Yes, it's the fee simple title that is assessed by the GN.
And can you help me understand again why your interpretation of the word demise does not refer to the lease? The reason I'm asking is that I did ask Baffinland about its position, and its position is that in the context presented, the demise is the area of land defined within the lease that provides Baffinland with exclusive possession. And I'm not sure, I would like to ask you your views on that and why the government of Nunavut adopted a different approach to its consideration of whether there has been a demise as defined in the Nunavut Land Claims Agreement.
So the lease is used by the assessors to determine the areas that have the most development activity. So when they are assigning the values in Part 1, Part 2, and Part 3, the lease is used for that purpose to determine the areas that have been subject to the most development. But it's only used for that purpose, for identifying what is the most developed, Part 1, what is the next most developed, Part 2, and the least developed part of the parcel being assessed, which is Part 3. But the GN is assessing in all cases with respect to this parcel, the fee simple title that has been demised to the Inuit, not the demise that has occurred within the context of the lease between BIMC and QIA.
All right, in the context of your submissions on the tote road, you made a reference to a reduction by 50% that the assessor had done in respect of the tote road.
Yes.
Might I ask you to display that for us using your share screen if that's convenient for you?
Yes, just a moment and I'll navigate.
Thank Thank you, sir.
Is it on the screen? What is GN assessing / taxing?
Yes, we have slide 24 on the screen, sir.
24. Okay, I have 22. Hold on here. Let me stop.
Oh, Ryan, I think you may be using your individual file as opposed to the combined file.
Okay, I got it now.
All right. Now, in listening to your submissions, I understood the submission to be made that the authority for this discretionary reduction was found in the Property Assessment and Taxation Act regulations. Did I understand that correctly, sir? It's the Property Assessment Regulations, I believe they're called formally.
To share my screen with respect to the affidavit. Just give me one moment. So this is the reference in the evidence. This is Mr. Town's affidavit, paragraph 81, where he states to recognize that some of the public use portion of the tote road located on the subject property, the assessment office has applied a public use allowance of 50% to all bridge and tote road upgrades reported by BIMC.
And can you help me, sir, understand what is the authority in the Act or the regulations for the application of an allowance on that kind, which would reduce the assessed value?
One moment.
Ryan, just so you're aware, you're still sharing your screen. I wasn't sure if you were aware of that or not.
No, I am aware. I'm just looking for it in the
You
regulation.
can hit pause at the top if you want, Ryan, while you're doing that.
Right. Yeah, I will have to get back to you on that one, sir. I'll have to confer with Mr. Towns to figure out where the authority is, if it is an explicit authority in either the Act or regulations.
Yes, sir. Let me say to you that the reason that I'm asking this is that the Property Assessment and Taxation Act allows this tribunal to step into the shoes of the assessor and exercise any discretion that the assessor exercised. So I'm wondering about the source of the discretion exercised to provide a 50% reduction in the assessment of value on the tote road on the basis of public use. I would like to know what the source of that was, please.
Yes, I understand the question, and I'll confer with my client and have an answer in the morning.
Thank you, sir. Now, Mr. Secretary, could you pull up the AF record again, please? And could you go again to AF2, paragraph number 9? Thank you, Mr. Secretary. Mr. Secretary, could you slide down to the next page and just display the boxes involving any one year? The 2014 year will be fine for this purpose. Well, yes, I think that's fine. All right. Mr. Baxter, I have a question about how the panel might tumble the numbers, I have called it, that are presented in these columns. Should it exercise its discretion in any, or its ultimate decision in any way to take one or the other of the crusher equipment or the tote road materials in or out of this equation? The Baffinland Council had suggested that the panel might leave it to the parties to tumble the numbers if the panel gave a sufficiently clear description of what may or may not be with assessable or taxable. And I wanted to ask for your views on that, were it to come about. Is it practical for the government of Nunavut to work with Baffinland and QIA to tumble the numbers if the panel can give you a clear description of what's taxable or assessable at the end of the day?
I'll defer to Neil on that, Mr. Council.
Obviously, things happen, but to date, the parties have worked together very, very well. And as you can see, there were a whole lot of numbers to go through and came to agreement on them. So if the direction was clear, I think the parties could do the math for the panel. And if the parties had any questions, obviously, of clarification, would go back to the panel. And but I'm confident they can work together for those to come to those numbers.
Thank you, Council. Are you able to tell me, Council, which statute adopted the Property Assessment and Taxation Act of the Northwest Territories as the applicable statute in Nunavut?
My understanding is that in 1998, it was called the Property Assessment Taxation Act. It simply copied that act and called it the Nunavut Act. And you'll see there's various amendments in there to change certain minor things, but that's my understanding.
Did the Nunavut Act have any
No,
application?
Nunavut itself adopted a Property Assessment Taxation Act, so it does have one. It just happens to be exactly adopted from the NWT.
Does the Nunavut Act have any bearing upon this? Or was there a separate act that would have done that?
I'm not sure I understand you. Maybe if I just call it up in Canley, maybe that'll help. Hang on.
If you would like to do so, Ms. Anil, it's 29 sub 4 of the Nunavut Act.
Okay, are you referring to something that you already want me to refer to, or?
I'm just wondering, I would like to make sure that I correctly understood how the government of Nunavut legally adopted the Northwest Territories legislation as the legislation for applicable in Nunavut.
And what section of the Nunavut Act were you referring to?
I believe it's section 29, subsection 4. I will read it out for you.
Oh, I've got it. Yep. Let me share. And
Thank you, Council.
too much going on here. No, that's not it. Yeah, wait. Got it. Here we are. So subsection 4.
Yes.
So you see that. Can you see my screen?
Yes, I can.
Okay.
And in a nutshell, my question is this the legislation that adopted the Northwest Territories Act as the applicable property assessment and taxation regime in Nunavut?
That is my understanding. And then in 1998, you'll see it became its own statute. Do you see that?
Yes, I do. That's fine. No,
but it is the same.
Yes, thank you. That answers my question, and you need not share your screen any further. Mr. Chair, that concludes my questions of this party.
Okay, thank you very much.
Trying to stop sharing.
I'd like to open up the questions to any of the panel members.
Okay.
We'll start with you, Paula.
Yes, I have one question in regards to the issue of transportation. I just want to clarify whether the GN Council would consider use of the road to get to hunting grounds to be a transportation use.
Yes, I think we certainly would. And just intended on that, if it was used for that purpose, pursuant to what is stated in the policies, that use would still be restricted and controlled. But I do agree with your point that if it was used to travel to hunting grounds, certainly that would constitute transportation.
Thank you.
Okay, thank you, Paula. Rick, do you have any questions?
Yes, I wonder if you could just go over the definition of local as PATA interprets the word.
I'm not sure I understand your question, Mr. Armstrong. Are you referring to the word local in the treaty?
In one of the slides, Ryan had.
Oh, and Ryan. Okay, I'm sorry.
Yeah, sorry. Maybe Ryan, one of your slides said local equals GTA. I wonder if you could describe a little more of that.
Local equals GTA?
Yeah, I thought you had something to that effect. Your definition of local, what is your definition of the word local?
So I'm not considering the definition of local for the assessment purposes. I think the definition of local is certainly important for the definition of real property taxation as set out in the Land Claims Agreement.
Now, Mr. Armstrong, maybe you're referring to when I was speaking about what are local services or local government services. And what I meant by local government services are all of those services provided in the general taxation area by the government of Nunavut. And I had sort of listed them all through. That's what I consider to be local government services.
Okay.
Any other questions, Rick?
No, that's good.
Okay, thank you. I have a few questions I'd like to ask. And so the first one's directed towards Ryan. And Ryan, in your opening comments, you commented you'll be speaking about the infamous tote road, and I'm getting the sense of this from reading the material on that. But in your view, why is it attracting that kind of reputation as an infamous tote road?
So, well, let me say infamous amongst the parties because it's one of the major assets that's in dispute. That I did not, and please don't take any, I was not attributing anything negative to the tote road. Infamous in the sense that it is a major asset in contention with respect to its value.
Okay, thank you.
Nothing further than that. Thank you for the opportunity to explain myself on that.
Okay, thanks. And in your presentation, you went into some detail about the restrictive nature of the road, Baffinland having control of it and so forth. And just to play the devil's advocate, and so the panel members have a full understanding. Do you think in a situation where there was public access allowed, but because of the heavy ore hauling, that it would be reasonable for a company like Baffinland to impose some restrictions because of safety? And doing so, in your view, does that change the category of full public access?
It's a great question, Mr. Chair. Thank you. So, from the GN's view, many of the measures are to mitigate risk because these are large pieces of machinery and equipment, and they're putting in mitigation to protect harm or risk to the public. So certainly the GN concedes and understands that. When we look at the case law, and specifically the case of the bulldoze operator in New Brunswick, where he was traveling on part of a highway that had mitigation measures in effect, there it was flag persons on the either side of the lane. That in and of itself, those mitigation efforts, although designed to protect the public, still rendered it to be not a public place. So the purpose, I would say, the purpose of, or the reason for the control and the measures does not change the fact that the intent, and I'm saying the intent as reflected in the policy, is for control. And I would agree that in large part, it likely is to protect. That doesn't change the fact that the intent reflected in the policy is to have a significant degree of restriction and control.
Okay, thank you for your answer. And I'd like you to, I didn't fully understand your presentation on why the assessor amalgamated parcels, I think it's P17, 16, and 19. He amalgamated them, I think you said, because of the commonality of the toll road. Could you just explain that part again?
Sure. So the reason for that is the definition of parcel in PATA. So in the legislation, parcel is defined, and I'm just navigating to that definition right now. And I can bring it up if that would be helpful, Mr. Chair.
Sure, that'd be great. Thank you.
So the definition that the assessor is following is in the definition sections at C under parcel. Parcel means if an improvement that is affixed to land would, without special mention, be conveyed by sale of the land, and the improvement, and here's the material part of the definition, the improvement is located on 2 or more blocks of land or tracts, then it is a parcel. It is one parcel. So because Etote Road, which the assessor views as an improvement, is located on those 3 parcel areas, it has been assessed as one parcel. The Etote Road being an improvement is the commonality.
Okay, thank you. That answers that question. My last question is to Jane. And Jane, in your presentation, you mentioned the Nunavut land claim agreement being finalized in 1993. And at that time, PATA was in existence and it was adopted in 1998. So I just wanted to make sure that what I was understanding from your point of view is that the parties that were drafting the land claim agreement would have been fully aware of PATA. And in your opinion, anything that they put in there into the Nunavut land claim agreement would be done so with the understanding that PATA was in existence and would come into existence. Is that what I understood?
Yes, but with the caveat that regardless of what PATA said, the land claim agreement stands on its own and stands above PATA. So for example, the provision in PATA in section 5 that says all land is accessible, then, you know, at first read, that would include Inuit-owned lands. But we know that's not the case because the land claims agreement says there'll be no tax on land except, and the 2 exceptions, or the exceptions to the exception. And no one went back to change that in PATA, but they didn't have to, because the land claims agreement would always govern over PATA.
Thank you. That concludes my questions today. I wanted to bring to the attention of all the parties that in the discussion that we had yesterday and today to invite supplementary submissions on jurisdiction, we've now, the tribunal, the panel members have agreed on what that question is going to look like, and we've included it in the record. And so I'll allow you to digest that overnight, and we will bring it up tomorrow and open up to full discussion if you have any comments on that. And also tomorrow, I would like the opportunity to be provided to both QIA and BIM to respond to the presentation today, if they have any. And then also a forum where all parties can respond to anything and take the time at this hearing to make sure that everybody has a chance to say anything that's important and they feel all parties should hear from. And if everybody is okay with that, then we can adjourn for today and meet back again tomorrow morning. Okay?
Thank you very much.
Thank you very much.
Have a good evening.